He actually lives in Santa Clarita, right around here. You know where Magic Mountain is? Yeah. A bit closer. What's that? Right. Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force called for Tuesday, January 25th, 2011 at 4 p.m. and starting at 4 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder?
Here.
Snyder present. Member Nee?
Here.
Nee present. Member Cawthon? Cawthon excused. Member Manny? Manny present. Member Washburn?
Here.
Washburn present. Member Caneva?
Here.
Caneva present. Member Wolf? Wolf absent. Member Chan? Chan present. Member Johnson?
Here.
Johnson present. Mr. Chair, we have a quorum.
Thank you. Just one quick request, which I'm about to acquiesce to myself. Please turn off your cell phones, or at least the ringers there too. Thank you. Mr. Clerk, could you call the first item, please?
Yes, Mr. Chair. The first item is presentation by Alan Grossman on the 6-vote majority requirement and its impact on complaints and other matters heard by the task force.
Okay. Is Mr. Grossman present? I don't see him. Okay, what we will do then is continue this until such time as Mr. Grossman is with us. Could you call the next item, please?
Item number 2 is continued hearing on complaint filed by Ray Hartz against the Library Commission for allegedly violating Section 67.16 by not allowing his 150-word statement to be entered into the minutes.
Okay, is Mr. Hartz present? Is the Library Commission representative here? Yes. Okay. Perhaps what we can do, absent with Mr. Hartz absent, would it inconvenience you very much to wait until Mr. Hartz gets here?
If I may respectfully request...
Never mind. Never mind. Mr. Hartz is here.
Okay. Does he go first?
Yes, he does.
Okay.
Mr. Hartz, we are just starting in on the item involving your complaint. Thank you very much for coming. You have 5 minutes. And this is complaint number 10054 against the Library Commission.
Good afternoon, members of the task force. Ray Hartz, and this complaint is against the Library Commission, and it is for failure to include in the minutes a 150-word summary that I submitted to them per the Sunshine Ordinance, which clearly states that any such submitted summary should be included in the minutes. And it is, I think, very clear because what they're using as a reasoning for doing that is the Good Government Guide. And basically saying, well, since the Good Government Guide says all these things, we can leave it out. Well, the Good Government Guide does not say you can ignore the law. It simply says there are all these different reasons, most of which I think are specious and really have no meaning. In fact, just earlier this week, late last week, I got a copy of the 2010-2011 edition of the Good Government Guide. And in this, Dennis Herrera writes an introduction, and he basically says the following. While I hope this publication will serve as a helpful general reference for departmental personnel, commissioners, commission staff members, and other public servants, it cannot anticipate every situation or question that may arise. Neither can it foresee the inevitable changes that policymakers, courts, and voters make to local, state, and federal laws. And here's the important part. So please be prudent. Understand that no publication can substitute for the careful consideration of the application of laws to specific conduct. Now, I have repeatedly gone before the Library Commission and said the law clearly states that if I submit a 150-word statement, or any citizen does, that summarizes our comments before a board or commission, that those comments should be included in the minutes. And instead of doing that, what they're doing is attaching it to the minutes at the back. It causes a couple of problems. One, most people who look at the minutes can't figure out where in the minutes those statements actually should appear. And as a result, it very often loses its effect. The second problem is what they then do is substitute in the body of the minutes their own interpretation of what was said. This case is really a strange one in that, oops, wrong sheet. The statement I submitted which was the summary. I'm sorry, you caught me off guard here, starting on time. Looked like this. And if you see, the top section is simply a statement of the law saying that these summaries should be included. And then the bold print on the bottom, it says the statement. And I read this statement verbatim and then used the remainder of my time to expand upon it. So a lot of the arguments that they put in the Good Government Guide, and unfortunately a lot of the arguments or questions that were raised by Mr. Threet in his memo to you, really go to this. I read it verbatim. So there's no question that what I'm putting in and what they asked them to put into the minutes was exactly what I said. The Brown Act basically says public meetings or governmental bodies have been found to be limited public forum. Any attempt to restrict the content of such speech must be narrowly tailored to effectuate a compelling state interest. So what compelling state interest do they say it serves by ignoring the Sunshine Ordinance, which clearly says that the statements we submit should be put into the minutes, and instead putting them at the back? I see no compelling state interest. What I see is an interest in taking comments of which they do not approve, putting them in a secondary position, putting them out of order so that it's harder for people to understand. And in this particular case, what was really bizarre was their supposed summary of my comments were the beginning introduction to my statement that I submitted saying what the law was. So what they actually put in place of my actual statement was the law saying that they should put it right where they put their little summary. So so basically, if you look at the minutes, and they're the minutes that were submitted to you, you'll see that in the body of the minutes it says, Mr. Hart submitted the statement and asked that it be put in there in accordance with the Sunshine Ordinance, and it lists the section. So they actually put it in there. So really what I'm saying in total is this is a choice between the Good Government Guide, which has no basis in law. It is not legal opinion. It is not legal anything, versus the law. And I'm saying the law should prevail.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Good afternoon, President, Commissioners, anonymous tenants here.
Excuse me.
I have to support Mr. Hart's all my dealings with this board and many others with our cases is that the staff of all the departments, they tend to take and adjust what they want you to hear and what will convince you, regardless whether it's fact, truth, or not truth, and therefore it sways your decisions and that type of thing. So I support Ray Hart's. Thank you.
Thank you.
Yes, I'm here to support the complainant also, but unfortunately I'm also here to chastise the Sunshine Task Force for putting the complainant behind the wheel or under the bus. I presently see 2, 4, 6, 7 members here when there's an 11 seats that are to be filled here. So automatically he has 5 people voting against him, automatically, regardless. So the distaste, everything, I'm here for the complainant, but obviously you guys aren't, because no matter what the complainant says, the 5 that are automatically voting against him are not hearing him, are not giving him an equal chance, and this is a rigged, false process that you've subjected him to. Thank you.
Thank you. Is there any further public Anybody else to present facts and evidence in support of the complainant? Seeing none, we're getting a little bit of interference into the audio system, and I would ask again, please check your cell phones so that we can remove that interference. Is the respondent present? Thank you for coming, ma'am. You have 5 minutes.
Thank you. I won't take that long. Good afternoon, members of the Sunshine Ordinance Task Force. My name is Mary Hudson. I'm the Senior Management Assistant in the City Librarian's Office, and I'm here today to represent Sue Blackman, the Library Commission Secretary, and to read this statement. She has sent you 2 emails requesting that this item not be scheduled for this week since she is on a previously planned vacation. She did attend the first hearing on this item on Tuesday, January 4th, at which time the item was continued. She sent you an email on January 7th requesting that the item not be rescheduled for the week of January 23rd, as she would be on vacation. The item was scheduled for a special meeting of the task force on January 20th, which is a regularly scheduled meeting of the Library Commission, so she could not attend. She sent another email on January 14th to the task force requesting that the item be rescheduled sometime after January 31st when she returns. I am again making the request to continue this item so she can attend the hearing. And that's my statement.
Okay. Are you personally familiar with the matter at hand, ma'am?
I am not. I work in the City Librarian's Office. I'm not a commission staff person. I'm not familiar with the commission procedures and able to answer your questions.
Is there any other reason that another member of the commission or its staff could not have attended who is knowledgeable in this affair? Somebody besides Ms. Blackwell?
Ms. Blackman's
Ms.
the only
Blackman,
staff person, and in regards to the commissioners, I'm not certain.
Okay. Thank you.
Okay.
Is there anybody here to present facts and evidence in support of the respondent? Seeing none of the matters with the task force, the first question that we have to deal with, of course, is whether we want to go forward with this or wait until next month. Member Knebber.
You know what? I'm tired of this. We put this forward already because you couldn't be here, and this is not the first time with the Library Commission, with Ms. Blackman specifically. So I would want to go forward.
Okay. Anybody else? All right. The chair detects a consensus for this to move forward. And the chair, as a matter of fact, I personally agree with Member Knebber. This has gone on for quite some time, and I think it is it's up to the members of the commission and the commission staff to make sure that somebody here is present. You know, this isn't coming in out of the blue. It's not coming in at the last minute. This has been well noticed. Some arrangements should have been made. That's my opinion. And with that, we will proceed with this. Task force members, do we have any comments or questions on substance? Member Snyder.
Yeah, just Mr. Hartz, could I ask a couple questions?
Yes, sir.
I just want to make sure that I'm clear on the facts. You submitted a under 150 word statement, which the Library Commission appended to the end of the minutes. Is that right?
That is correct.
Did they alter that statement in any way, or was it verbatim with what you was it identical to what you submitted?
It was verbatim.
Okay.
And I this was a recorded meeting of the Library Commission. Ms. Blackman said, "City Attorney has directed us to include public comments with the minutes. They do not have to be in the body of the minutes, but included as attachments to the minutes." And again, that is not advice from the City Attorney. That is simply what they glean from reading the section in the Good Government Guide, which really doesn't say, hey, it's okay to do this and ignore what the law says. It simply says, for all these reasons, you can append it.
But there was also a summary of what you testified to, which the Library Commission produced and put into the body of the minutes, correct?
This was what I submitted, and it's in your packet. This was what I actually read. This was my actual summary of the statement, and I actually read it, and then after I was done, I commented on it. What they put in its place in the body of the minutes is this, which is my request that, under the Sunshine Ordinance, that this statement be put into the minutes. That's, if you look at the minutes, which she actually provided you for that date, and you look in the body of the minutes on...
I believe
Page 30 of our packet.
It's on page 7 of their submission. And it says, the second paragraph at the bottom, Ray Hart, San Francisco Open Government, said he asked that the following section of the Sunshine Ordinance be included in the minutes. And that wasn't. What it was, I want this statement included, and they included my quotation from the ordinance.
So, correct me if I'm wrong, but your complaint is twofold. One is that the summary of your testimony, which the Library Commission put into the body of the minutes, was not a complete
It wasn't.
or accurate.
If you look at the two, you compare them. There's absolutely nothing to do with one another.
Okay, so that's one part of your
Right.
complaint. The second part of your complaint is that they should have put the 150-word submission by you into the actual body of the minutes rather than as an addendum.
Yes, at the point where the comments would be made, so that people reading the minutes would be able to go down and say, okay, it was in this item that the comment was made at this point in the minutes.
Okay.
So it's accurately reflecting the actual flow of the meeting.
Okay. Yeah, that's all I had. I don't know if anybody else has questions.
Member Knebber? Okay, I do have a question.
Sure.
Either Mr. Hartz or the library representative can answer. Couple of questions. First of all, I think page 34 at the very bottom repeats
Is that
the
34 of our
the item
packet?
on page 30, and if you go up to page 35 in the italicized type, I believe that is the actual comment that you actually submitted. Is that correct, Mr. Hartz?
My pages are different because I have just all the documents.
Okay, I guess in the minutes themselves it would be pages 11 and 12 of those minutes, and in the packet we have its pages number 34 and 35, and
That's not part of the minutes, though. Page 34 is a letter separate.
well, page 34 I believe repeats what is at the bottom of page, what Mr. Hartz pointed to on page 30, which is the Library Commission's summary of what he said, but it is not his own summary. And please let me finish. I believe what Mr. Hartz is saying is that the summary included by the Library Commission or by the Secretary of the Library Commission does not accurately what Mr. Hartz said. And I think if you look at the italicized type at the bottom of page 34 of our packet, compare that with the italicized type at the top of page 35 of our packet. Noticeable difference, and I think that's very relevant to what we're discussing here. Another question that I have that Mr. Hartz or the library representative might be able to answer within the minutes. Is there any notation either at the top of the minutes or within each item that the 150-word summary submitted by the member of the public is appended? And I think that also is relevant and important.
No, it is not. It basically, they substitute their, whatever they want to put in place of the statement. And then at the end of the minutes, after the secretary has signed the minutes and put her signature on it, they put some disclaimers saying the following are are statements submitted by members of the public, and we don't endorse them. We don't, basically a bunch of disclaimers.
But do they make any notation
No.
at all that the actual statement or the actual 150-word summary submitted by the member of the public is appended and can be found at the end of the minute?
They make nothing in the minutes to say it's appended, and they put nothing in the appendix or the appended minutes to indicate which item it applies to. So basically the person might have 12 pages of minutes and have this loose comment sitting at the end, which they have no idea which of the agenda items it applies to.
Okay, thank you. Member Washburn?
Actually, on page 31 to 32 at the bottom is the attachment to the end of the minutes. So if you look on page 31, mid-page, you'll see Sue Blackman's signature, and then you see there's a paragraph that begins explanatory documents. And then from that point on are just some additional items, but there's no reference under agenda item number 5 where Mr. Hart's read that statement. There's no referral to the appendicized material.
Okay. Further questions from the task force? Member Snyder?
I have a question for the Library Commission representative.
Ma'am, could you please reapproach?
Hi, I'm sorry, I missed your name the first time around.
Mary Hudson.
Hi, Ms. Hudson. You may not be able to answer this question, but the question is, do you know what the Library Commission's reason for not including the 150-word statement in the body of the minutes is? Is there some technical or...
I'm not the correct person to answer the question. I'm sorry.
So you don't know
I'm
why?
not sure.
You don't have any idea of what the basis
As I
for...
said earlier, I was only here to request the continuance. I'm not here to address your questions. I'm not the appropriate person.
All right.
Thank you. Member Johnson?
Mr. Hartz, I wanted to make sure, I know you said this before, but I wanted to verify that you read that exact statement into the...
Yes.
Have they approved these minutes?
Yes, they have been approved, and these were back in September.
Did you make any statements during that agenda item about approval of the minutes?
Yes, I did. And unfortunately, members of the public who object to what's in the statements, they will listen to them. They will allow them to give their, I don't like the way this was said, and that wasn't what I said. But then when they actually make the motion to approve the minutes, they only approve the minutes as appended by the members of the commission.
In the minutes, that's
Yeah.
what they put. So they didn't put your comments about disapproval of the minute.
Right. In fact, I submitted 2 or 3, I'll be honest with you, I can't remember offhand, statements specifically addressing the issue, and I've repeatedly said to them that the law clearly says one thing and you're choosing to do something else.
Okay, thank you. So I would agree with Chair Nee that if they had better represented what he said, maybe it would be okay to attach it at the end, but it's clearly not what he said.
Member Knebber?
Yeah, I do think that they need to make reference within, and I do think that the Library Commission is making a clear choice to say, hey, we have to put these in at the end. We're not going to endorse them. We're not going to say that these were actually said or not. Whereas I think the intent is to represent everything that was said at a meeting. And if somebody wants to do their own 150-word summary, they can, and that should be included inside the minutes and shown as part of the proceedings.
Member Johnson?
In addition, one other question that I have. The Library Commission meetings are not audio or videotaped? I tried to listen to this and I couldn't find it.
Ms. Hudson or Mr. Hart?
I can answer that.
Okay.
We do provide audio and DVD, not video of the meeting, but we do have audio tapes available.
But is it on? It's not on your website.
And it's not on the web.
So it's very difficult to even ascertain that would be what he didn't say without knowing that I could. Because I tried to look it up on the website, but it's not there. Right. And it's really helpful to the public if you do have at least, I mean, like we don't have video, but we do have audio up there. So thank you.
Mr. Hartz?
One of the arguments and one of the questions that Mr. Threet put into his thing from the Good Government Guide was basically that someone could submit a statement written that didn't reflect what they actually said. And I told them, I got up before them and I said, I have no problem with that at all. There is an audio recording, and if you want to say Mr. Hart says one thing and writes another, I would be willing to let any member of the public look at listen to the audio record, look at the statement I submitted in summary, and tell whether they think it's a real reflection of what I actually said.
Thank you. At this time, the respondent and then the complainant will each have 3 minutes to provide any concluding or rebutting remarks. Ms. Hudson, do you have anything to add? No. Okay, Mr. Hart.
I think this is really very clearly an issue that includes the Brown Act. Because bottom line, the Brown Act says that you can't do anything to limit public comment without a significant, a significant government interest being met. And basically, I think most free speech people will tell you that whether it is a oral presentation you're doing or the summary of the presentation, it's still your speech. And it reflects on how you are saying something. And I have gone through over the last 7 months all of their things. And basically, and I'm not joking, you can go back and look at the record, when I make my comments, if I make comments or reflect positively on the Library Commission, those get put into the summary in the minutes. If I make comments that are, in their mind, not what they like to have in there, those are either eliminated or toned down. And this was the only way I felt that I could get a reflection of what I was really saying, and they did not like that. I mean, basically what we're saying is that we're going to take the person's comments, we're going to abridge them, we're going to put them in a tone I want, and we're going to put them in the body, and then we're going to take what the person actually said in the summary and relegate it to a secondary position, and do it in such a way that nobody could figure out what it applies to in the body of the minutes. And I think this is really an intent to keep political comments or disagreements on how they do their business, procedures, policies, and so forth out of the actual body of the minutes, rather than anything to serve any sort of public interest. And I'm doing this not for myself. As you notice on this attention, there are other people who had submitted additional comments, and theirs were actually put to the back of the minutes also. But the law clearly says, it couldn't get much more clear. If a person chooses to submit it, it goes in the minutes. If I want to write something to a board or commission, I can do so. If I feel more worked up about a particular item, I can go there and speak on it. And if I really feel it's important, not only that I get my word out there, but it reflects actually what I said, then I submit a 150-word statement. And I think those are 3 levels that any citizen ought to be allowed to use to ensure that the comments they are making are actually reflected accurately, and that so if they have any desire to bring to their attention things they feel that the individual feels they are not doing and should be or shouldn't be doing and are, those actually make it into the minutes. And one of the things the Brown Act goes on to say is that any change from this outside of a significant government interest is really done to maintain the status quo and to calm people's comments. In other words, to do them. They say it's not a bridge. If you take a 150-word statement and abridge it down to 15 words, or cut it down to 15 words, how could anybody in their right mind try to say that's not an abridgment?
Thank you. Matters back with the task force. Before we go further, Ms. Hudson, I have just one quick question. Is Jewel Gomez still the president of the Library Commission? Thank you. The respondent indicated yes, she is. So thank you very much for that. Task force, does anybody have a motion or further comment? Member Washburn and then Member Snyder.
I move to find a violation of 67.15, 67.16.
Okay, is there a second?
I would.
I believe Member Chan seconded. Member Snyder, Member Johnson.
I would just, it's not really even a friendly amendment, but I would support the motion, and I just wanted to maybe supplement for the record what our basis for it is. I would just say that 6715, I suggest that we're finding a violation of 6715 because it's clear that the Library Commission altered Mr. Hartz's statement such that it constitutes an abridgment under the Sunshine Ordinance. And then I would say for 6716, the task force finds a violation because the requirement of the ordinance that the statement be in the minutes means that it should be in the body of the minutes, not attached as an appendix or an addendum.
Member Johnson?
I would suggest a friendly amendment to add 6721E
Yes.
for failure to send a knowledgeable representative about the minutes.
That's acceptable, yeah, I forgot to add that.
Second accepts?
Yeah.
Okay, further comment? I have a couple of things. First of all, regarding 67.16, the task force has I think this has come before us before in terms of where in the minutes the summary of a public comment should be. And I think the task force, as I recollect, and I may be incorrect in this, but it seems to me that the task force found it acceptable if the actual comment or the 150-word summary of the comment submitted by a member of the public was appended. But what does bother me here is that there is no notation of the appendation, if that's the word, being or appending. There is no notation within these minutes that the appending occurred, and that is of concern. So in this case, I would support the finding of 67.16. I also support the finding of 67.21E, and I think in that case, we should actually name the Library Commission President, Jewel Gomez, as the person responsible there, particularly since Ms. Blackman could not be here and has apparently legitimate reasons for not being here. I think in this case, the buck has to stop with the President of the Library Commission. So I would, if it's acceptable to the second and the maker of the motion, I would add the name of Library Commission President Jewel Gomez to 67.21E. Second accepts?
Yes.
Maker accepts. Further discussion? Roll call, please. I'm sorry. Public comment. My mistake. I apologize. Is there public comment on this item? Thank you for coming, sir. 3 minutes.
Thank you, Mr. Chair.
And thank you for reminding me about public comment.
I'm Peter Warfield, Executive Director of Library Users Association, and I'm glad you're taking this up, although it seems to be somewhat belated. And I'm not sure if the 45-day time limit applies to meeting issues as well as to document provision issues. But certainly the repeated delays are unfortunate. The library has some 900 plus employees. It has about 500 plus full-time equivalents. It has a library commission numbering 7 members and including a president. These library commissioners are the ones responsible, and certainly I think it's appropriate to identify the library commission president. Any one of those people could have come to this meeting and provided information for you as best as they could. Now, they did send somebody, but not somebody from the Library Commission who is the responsible party for the actions done, the preparation, the approval of the minutes. Second of all, I heard somebody say that if the minutes were better representative of the comment, that it would be somehow okay to ditch and lose the 150-word comments at the back. Unfortunately, there's no way of knowing beforehand how reliable the library's minutes are. I have personally experienced a whole range of offenses, including saying the exact opposite of what the person said, including on a very hot political topic, namely RFID, giving literally 5-word sentence fragments for what people from the public said. Incomprehensible. So whether they do a fabulous job or a lousy job, those 150-word comments provided by members of the public should be allowed to be placed where they are relevant, and that is at the item, as the law says. What the minutes require under 67.16, a brief summary of each person's statement. The minutes shall state, and so on and so on and so on. And provide a brief summary and so on and so forth. I think that clearly any person speaking during a public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. Now, the library has done its best job possible to ditch these things after the commission secretary's signature, after a bunch of explanatory documents rubbish that has nothing to do with this document. There aren't any explanatory documents here. It's all in the agendas. And then they junk Mr. Hartz's comment number 5, and several pages later, the anonymous citizen's comments on item 5. There's no way for anybody to make sense of where is what and where is it, and is this even part of the minutes, unless they go through every single word with a magnifying glass.
Your 3 minutes have expired. Could
All
you
right.
wrap
So
it
I
up,
hope
please?
that you will find all of the violations that you have moved in this motion.
Thank
you.
Thank you. Sir, you have already spoken during.
I'm not part of the public now?
No, you're not. You've already spoken on this matter during. Sir.
I'm sorry, I apologize.
Okay. Further public comment on this item. Seeing none, public comment is closed. Matter is back with the task force. Is there any further discussion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manning?
Aye.
Manning, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Thank you. That concludes this item. I would ask again, is Mr. Grossman present? Okay, then item 1 is remains continued. Could you call item 3, please?
Item number 3 is continued hearing on complaint filed by Dorian Maxwell against the San Francisco Municipal Transportation Agency for allegedly refusing to provide information contained in his personal file.
Mr. Maxwell. Thank you for coming, sir. You have 5 minutes.
Thank you. They gave me some of the documents, everything except 2 documents that I still need. And one of those is the email that was attached to the photograph and the inspector's report. So they did give me most of the documents that was requested.
Okay. Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming. You have 5 minutes.
My name is Rumi Ueno. I'm the current Employee and Labor Relations Manager for SFMTA. With respect to Mr. Maxwell's request to review his personnel record, I think it's important to note that certain of the items he was seeking would have either been premature to have been filed in the personnel record, or it would have been inappropriate. If Mr. Maxwell was seeking information related to a pending disciplinary matter, it would have been premature because he hasn't exhausted all of his appeals. If he was seeking information related to a grievance, it would have been inappropriate to place that in official personnel record, as it's potentially prejudicial to place it. Those things are filed separately. My understanding is that Mr. Maxwell did make an appointment to view his record and found the documents to be missing. But based on our procedure, it would have been, in one case, depending on the type of document he was seeking, it would have been premature, and in another case, it would have been inappropriate to file.
Hi, I'm Cynthia Chambers, an Honoria Maxwell superintendent, and he has the right to come into the office of the superintendent's office with his shop steward and review any files that he has there. And he has been able to come in with his shop steward last month and review every file that he had. And I also assisted him in another matter where he needed documentation for something that transpired with him a couple of years ago. So as far as my department is concerned and as superintendent, I've tried to help him in every way with anything that he's needed. Thank you.
Thank you. Thank you both. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter with the task force, Member Knebber.
Mr. Maxwell, can I ask a question? I just want to be clear on what you got and what you didn't get. So you got most of the items. What are the two items you said that you did not receive that you had requested?
The only two that I haven't received yet was I was interviewed by an inspector, and there was an inspector report made that would have exonerated me from this matter. And I was looking at the photograph, and it's not time-stamped on the photograph, so it had to be a letter or something attached to the photograph to adjust the validity of the photograph.
Okay.
Those are the only two documents.
Okay, those are the two. So the inspector's report that of the interview with you, and then an attachment an explanatory attachment to the picture telling what it is and what the time, that date, and stuff, right?
Exactly.
Okay, thank you. I'm sorry, from the representative, Ms. Chambers, I guess. I don't know, or maybe either of you. So, would the inspector's report be in this if there was one in his file?
Can I give it some context here? I believe what Mr. Maxwell is referring to is what's commonly referred to as a Skelly packet.
Mm-hmm.
So for a public employee who is whose potential discipline is pending, we are to provide pre-disciplinary due process, and that typically entails a notice that says what we're proposing or recommending.
Okay.
In that packet, I believe he believes something like that should be contained in it. For whatever reason, that was not used to support the proposal.
Okay.
So he's not entitled to something that we didn't use to support the recommendation.
Okay.
I think that's where we have a disagreement.
Would this inspector's report exist somewhere, just not in this packet? Would it be in some other file, or is your contention that this doesn't exist?
I don't know if it exists or not.
Okay. So secondly, how about this attachment to the photograph? Would there be some sort of attachment as he contends to this photograph, an explanatory document to this photograph telling a time, date, stamp attachment?
I don't know of its existence. If it does exist, but the employer chose not to use it in the packet, he would only be entitled to the packet we're relying upon to support our proposal.
Okay.
Mr. Maxwell came to my office on Monday.
Microphone, please.
Oh, sorry. Mr. Maxwell came to my office on Monday, and I gave him his Skelly packet. In this case, I don't think that there was an inspector's report there.
Okay, that's what I'm trying to get to. I want to understand if you guys have seen this, or if you think that there is this.
If it's an inspector's report, I don't know what the relevance would be on this case.
Okay, thank you very much.
Ms. Chambers, could I ask you A question before you leave? Thanks. Sorry.
Yes, I've driven the bus before.
In his complaint to us, Mr. Maxwell said that he requested records on October 18th. Did you receive a request on that date? Was that the date that he came in and reviewed the file? Do you know anything about that October 18th request date?
I'm trying to recall what it was that he wanted, but I believe that on the last meeting that he had here, he was outside and he told me that he had not I wasn't there when he had his Scully hearing. So when he came in on Monday, I gave him his Scully hearing paperwork. I also gave him some memos in reference to the violation that he committed. And there was a picture there, but it didn't have email, and I gave him that. But anything else, he hasn't exercised all of his rights in his hearings, and that's what he's entitled to. And he has to wait for his hearings to request that thing. And in his Scully hearing, he wasn't as cooperative to ask for these things.
And when was that hearing again? I'm sorry.
That was, I think, the end of September.
Okay.
His first hearing. So I think that's why he's asking for all this stuff now, where had he remained calm and been able to communicate with the person there, he would have been able to get some of the stuff. I don't know.
Do you remember receiving a letter from him on October 18th asking for the letter that we have in our packet is from him addressed to you, asking under the Freedom of Information Act, the Sunshine Ordinance, to receive certain documents?
That's what he received on Monday.
Okay. So did you receive that letter on October 18th or thereabouts?
I don't remember if I received it on that day or whatever day.
Did you respond in any fashion after that?
No, I
in
did
October?
Not. No, I did not, because he had a Scully hearing to offer that. We have a procedure and a process. And so, when he had his next Step 3 hearing, he could have asked for that stuff again, and he did not. Every time that he has a hearing, if there's something that he wants, he's entitled to ask for that with his union.
Did you explain that to him? What you just told me, that you're entitled to this information, but you're entitled to it under the Scully process.
I think I talked to his shop steward in regards to his case. He does have a shop steward at the division that if there's anything that he wants or whatever, he can have it. It's the same thing that he did when he came into my office and looked at his files, because there was something in particular that he was looking for, and I also assisted him with that. But he does have a shop steward there, and he does have a union that anything that he wants, they're supposed to supply that for him.
Thanks.
Okay.
Thank you. Further questions? Okay, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Ms. Chambers, Ms. Uno, do you have anything to add or any concluding or rebutting remarks?
I'm superintendent of Patrol Division, and I'm responsible for 280 operators that operate buses in this city and county of San Francisco. I'm a native San Franciscan. I've been a driver, I've been a supervisor, I've been a training instructor, and now I'm a superintendent. My job is to make sure and assure that the people of the city and county of San Francisco get good service and have operators that are there to supply good customer service and go back and forth within this city. We do have operators that feel that the company's not doing what they want to do. We do have rules, we do have regulations, and we do have procedures and process. And my job is to make sure that I work as management with the unions and with the operators to comply and give them what they want. That's the reason why when Mr. Maxwell came in and wanted to see his files, I knew that he could see those. When he requests things, I can do that. But it's really hard to communicate with someone that at times they're a little bit non-communicative. I have to overlook that. I told Mr. Maxwell I'd give him whatever I could, and I did that on Monday. So I don't know what else he wants. So everybody's trying to do their job, and I try to do mine also. Thank you.
Thank you. Mr. Maxwell? You have 3 minutes.
The documents that I'm requesting would have exonerated me in this matter. And I did serve them the letter, and I had it stamped by the division secretary that they did receive it. If she read it or not, I don't know. But as a person of an employee, I do feel that I'm entitled to some type of response. I mean, I felt totally disrespected that I put something in writing to them and didn't get a response back. These documents, they're trying to fire me. And these documents would have exonerated me in this matter. And my constitutional rights do not end at the MTA. My constitutional rights carry me wherever I go. And they're denying me the right, my Sixth Amendment right, to review incriminating documents that would have, in fact, saved me. I requested those documents all through the process. The union ignored me, they ignored me. So basically, that's why I came here before you to try to get help. And I appreciate the information that you gave me from the city attorney in respects to my matter. And I greatly appreciate that information. Thank you.
Thank you. The matter is back with the task force. Member Johnson.
Mr. Maxwell, I have a question about the inspector's report that you think may exist. Do you believe that because you were interviewed by an inspector?
In that inspector report, the inspector came and searched the bus.
Were you present?
Yes, I was present.
Okay.
And the materials that they claimed that I had didn't exist.
And so you believe that the reason you believe that report may exist is because you saw the inspection take place. That
report does exist. And I asked for that report because that report would have cleared me. They didn't, anything that would clear an operator, they don't want to use it. Okay. They want to use everything that they can to support their agenda to get me out of here.
Okay, thank you.
Okay, thank you.
And then I have one follow-up question for the MTA. Whichever one of you would know about the personnel file. I know that you had stated that only certain documents that would be supportive of, I forget what it's called, Scully hearing? Skelly hearing would be included. But eventually when that is over, when the series of hearings is over, if there was an inspection of an employee's, an interview or an inspection of some kind, how would the employee gain access to that information since it is part of, a personnel issue? Is that ever available to him, even though you're not? I mean, if there was an inspection, it is part of what happened to him at work.
I'm not sure I understand your question. In the Skelly process, the employer has to provide the supporting documentation that presumably supports the recommendation for whatever level of discipline.
Okay, I understand that, but if you stop right there...
Well, if I may explain, if we don't use an inspection report because we don't know of its existence, we obviously are not legally obligated to produce it because we're not relying upon any information contained in that report to support.
Wait, you're talking about a specific incident? You're talking about supporting a specific incident. And if there was an inspection related to an employee, that should be part of that employee's personnel file, or it should be documented somewhere, even if it's not used to support a specific hearing or incident. So if
No,
somebody...
That's not how Skelly works.
I'm not
Skelly-
talking outside of Skelly, which is related to the
Okay,
incident. You're
how-
trying to prove
well, then
something.
let me explain how the Skelly documents may eventually land in a person's personnel record.
Okay.
That is, after all the appeals are exhausted, assuming the person disagrees with what the recommendation is, he or she can appeal through the grievance procedure in the relevant labor agreement. And then eventually, if they do appeal it all the way up through arbitration, and there's an arbitration decision and it's upheld or modified or whatever, that information gets placed in the official record. But right now, it would be premature in the case of Mr. Maxwell. But that doesn't mean that everything that's related to the arbitration gets placed in the record. What the eventual outcome gets placed in the record.
Doesn't
as
the
to what
employee have
level of
an
discipline is.
overall personnel file where
Yes,
all the
and
documents would be?
subsequently, after the documents are placed, should Mr. Maxwell wish to review that to make sure it is indeed complete, he has a right to do that.
Okay.
And he would do it in the same manner as he did previously, which is to contact the person that we have who's in charge of scheduling the appointments to ensure that there's ample time for him to review his record. So eventually, yes, it would be placed.
Okay, thank you.
Member Knebber?
Can I ask you one more question, just to clarify? So, if I understand this right now, he only has access to his file in regards to this complaint. Any other documents he can't look at? So if there is an inspector's report and it's not in there, he doesn't have the right to look at it, even though it deals with him?
Well, I think it's, let me just clear up an assumption. He has an official personnel record,
Mm-hmm.
right? And as explained previously, anything that hasn't, because there is no final outcome at this point, it would be premature to place anything in his file. As I said, eventually something may be placed, depending on
Okay.
the outcome tomorrow.
Okay, thank you. I still think, the request is for all documents regarding this case. It doesn't say everything in his personnel file. It doesn't say things in the Scully document file. It's all items that have to do with this case. And I just, it's actually a little bit off-putting to me that it's this hard to say that because it's not under observation or not part of the proceeding that he can't look at it, or it's not there, or it's not available. I don't know.
Member Wolf?
Yeah, I'm not quite sure what you're inferring then, Member Knebber, but I do want to ask if you have determined whether the documents that are missing are actually public documents. And if they are public documents, whether they can be producible even if redacted.
Member Knebber?
Well, we at this point, Member Wolf, we're to the point where he says that he's gotten most of the documents, and the things that are at issue are a inspector's report, an inspector that came in and looked on the bus, according to him, and was put aside. The respondents are saying that is not part of the official record, so it's not included in what he can look at. And he's also looking for an explanatory letter or attachment to a photograph of the document that, again, he says has to be there, so I'm not as sure about that. That's why I'm focusing more on the inspector's report. If there was an inspector on the scene, I would have to assume that the inspector made a report, and I don't see why that would not be included.
Mr. Threed, I believe, has a comment.
Through the chair, I just wanted to offer a couple of comments that might help clarify the inquiries. There seems to be at least some confusion among, I'm not sure it's confusion. There seems to be a mixing of two different questions in the discussions that are happening. And one is what is required to be provided to an employee who's the subject of a Skelly hearing, and those requirements are the subject of a specific statute that deals with Skelly hearings. And the second issue is what documents are required to be produced to the complainant who has made a public records request, and that's a wholly separate issue that is not governed by the rules that govern Skelly proceedings. So with that, I'll leave it to the commission.
Member Wolf?
I would just like to point out that if there's going to be some reference to Section 6254 in paragraph C, where it talks about the exemption of disclosure for personal, medical, or similar files. The question is whether it constitutes an unwarranted invasion of personal privacy. But if the person in question is asking for their own records, then there is no unwarranted invasion of their own privacy. They're asking for their own records. And this subject has come up before us many, many times. So we really have to be very clear who is asking for the information, and is the information pertaining to them personally. And if so, then those records should be made available to them and should be declared public.
Member Knebber.
Or
and
at the
Member
very
Johnson.
least, my line is that there should be a reason why those ones have been held back. It's not just that they're not available, they're not in that file, so you don't have them. Well, why aren't they? They were asked for. They were not at the Scully file. It wasn't asked for the Scully case file. It was asked for these specific documents. Now, if they are proved to be not public and they provide reason, that's something different. But they're saying that wasn't in the Scully file, so he can't have it. And the complainant's request was not for what was in the Scully file. It was for these documents that had to do with this case.
Exactly.
Member Johnson, Member Snyder.
I have a question for Mr. Maxwell, if that's... Do you have a union representative other than your shop steward?
Yes, ma'am. We have the financial secretary, the executive vice president, and then
Did you have somebody with you at the hearing? A union representative outside of just your supervisor at that particular location?
Yes, ma'am. I had my shop steward, Gene Ellis Jones.
Is your shop steward your supervisor?
No.
No, it's separate. It's your union.
Ms. Chambers is my supervisor.
Okay, and then the union representative
and then the union
is...
representative just come in and advocate like an attorney.
Right. Did they ask for your personnel file that wasn't included in the Scully hearing? Or do you know?
I think the staff rep, I believe he did at the Step 3 hearing. He did ask for that. That was after the Skelly hearing. He did ask for the documents. And then at the first arbitration hearing, the arbitrator subpoenaed those documents. So,
did you receive whatever documents were produced in response to the subpoena?
No, I haven't got those. I got everything else but that particular attachment to the photograph that they're trying to use, and the inspector's report, which I believe the staff rep that was representing me at that hearing, I think he did ask for it.
Is part of your discussion at the hearings the time of the photograph? Is that in dispute at your hearings?
Yes, that's it. That is in dispute.
And have they produced any? How are they representing when the photograph was taken to you?
At the hearing, verbally.
Is it the person who took the photograph, or just whoever is at the hearing doing the hearing?
Just the person who's at the hearing, not the person that actually took the photograph. And there is a provision in our MOU that states that I have a right to face that person that took that Appendix A of our MOU.
Okay.
I do have a right under even the Sixth Amendment right under the Constitution that says that I have that right to face my accuser.
Okay. Thank you very much.
Okay.
Thank you. Member Snyder?
Yeah, I just wanted to elaborate on something that DCA Threet and Member Knebber said, and that's that there is the Sunshine Ordinance sort of overlays all of the other concerns that we're talking about. And the MTA, when they received the letter from Mr. Maxwell, needed to respond according to the Sunshine Ordinance. He invoked the Sunshine Ordinance and said, I'm requesting these records. And at the very least, the MTA, under the Sunshine Ordinance, needed to respond within a certain amount of time saying we can or cannot provide you with records, and here's the reason that we cannot, if we cannot. And I've heard no evidence that they did that. Setting aside the question of whether these records are public or not, the MTA is still subject to the Sunshine Ordinance, and I understand, and it appears that the MTA has done, a good faith, has made a good faith effort to follow the proper Skelly procedures, and they've appeared here before us to explain all of that. But at some point, MTA needed to talk to somebody, whether in the city attorney's office or the MTA itself with their public information office, to say, what do we need to do to respond to the Sunshine Ordinance request? And what you would have learned if you had asked that. And I understand it's a whole other layer of issues and a whole other layer of law, but that's the way the city has set it up. And so the MTA needed to respond to the Sunshine request, and I haven't heard anything that suggests that they did. So in my view, there's a violation for failure of 6727 for failure to justify withholding, and there's also a failure under 6725 to respond in a timely fashion to the Sunshine Ordinance request. And I'll leave it at that.
Is that a motion?
No.
Further discussion? Is there a motion? I'm not sure that the lack of, there is a total lack of response here. According to the complaint itself, if you look on page 37 of our packet, he does say that on October 27th, they refused to furnish requested information, see letter of request attached, and the request was made on October 18. So that's within the required 10-day time frame. So I'm not sure that 67.25 would apply here, but I do agree that 67.27 does. Member Knebber?
The only way I disagree with that is by Ms. Chambers' own admission. She said that she did not respond to the letter.
Okay. Member Snyder?
And Mr. Maxwell testified at the earlier hearing that he never received the response. But could I actually, Mr. Maxwell, could I ask you a question again? So there's this discrepancy. In your complaint, you say that they refused to furnish the requested information on October 27th, but you said earlier that they didn't respond to you in any fashion. Now, I know that they've now responded and that on Monday they gave you information, but casting your mind backward to October, did they respond to your letter that we have on our record, which is dated October 18th?
No, they never responded.
So, but why in your complaint did you say that on the 27th they refused to furnish information? Because that implies that they responded in some fashion and said, no, you can't have it.
Oh, it was just a wording. It was just a wording issue with that.
Okay.
I really didn't. I was just trying to get it in within a timely manner, so I was just trying to.
Oh, you're saying they did not respond by October 27th?
They didn't respond at all.
Okay, so what you were trying to say there was they didn't respond by October 27th.
Yeah, that is correct.
All right, got it.
Thank you. Is there a motion? Member Johnson?
I would definitely make a motion to find violation of 67.25 for failure to respond at all by the respondent's own admission. And then based on, I would also add to that a violation of the California Public Records Act 62.54 because it does not warrant an invasion of personal privacy since it's his own records. And based on that, under the Sunshine Ordinance 6726, withholding kept to a minimum, they're stating that he only has access to the hearing records rather than his whole file, which they may need to review that section of whatever labor contract governs that to make it correspond better with the Sunshine Ordinance. So, and also that 67.27, the justification of withholding.
Is there a second?
Second.
Moved and seconded. Discussion. Is there?
Could I ask a question to
Member
clarify?
Snyder?
Are we? Was the motion to also find a violation of 6726 of the Sunshine Ordinance, or were you just?
I'm adding that, yeah.
Yes.
Okay. And 6254 of the Public Records Act, you're saying?
Yeah.
Is there public comment on this item? 3 minutes each. Thank you.
Thank you. I'm here once again to chastise the Sunshine Task Force because while this man has come up here, and from the very small time that he's come up here, I've heard that they're doing constructive termination on him. They're trying to get him out. And he needed these records so that he could prove whatever his position was and that he had constitutional rights and other rights to face his accusers. Well, unfortunately, the Sunshine Commission is once again putting him behind the 8 ball and throwing him under the bus because of due process. If he has the right to look at his accusers, he also has a right to have his judges hear what he's saying. And right now, I see that there's 2, 4, 6, 8 people here, but there's 11 seats. So I am speaking to the remaining seats that are empty and asking, why is it that they're voting against him? Why are they throwing him under the bus? Why is he already subjected to all this, in addition to the fact that, this is a poor man trying to get his due process and being thrown into another monkey farm here where he already has 4 votes against him regardless, and they're not even here to attest or listen to his testimony. He has the right to his accusers, but he doesn't have the right to tell the truth to the people who are going to judge him. Boy, is that ever correct. What a farce.
Thank you. Is there further public comment?
Members of the task force, having a lot of experience, my first dealings with human resources started as a member of the command staff at Commander-in-Chief Pacific Fleet in Honolulu. And we dealt with a lot of complaints around discrimination, whatever. And I think Ms. Johnson and Member Snyder probably recognize one of the first things that can trip you up if you end up in court is if you didn't use all the internal processes and complaint procedures and whatever. You go to the court and they say, well, did you talk to your supervisor? Did you talk to your manager? Did you do this? Did you do that? And if you didn't do it, they say, go back and start over. So I have to give Mr. Maxwell a lot of credit. Now, on the side of the department, I think what I'll surmise here is that there was an inspection. The inspector filed a complaint. They went through and they said, oh, good, we have the complaint. We're going to use it. And then somebody caught on to the fact that there was never an actual formal complaint form filled out. And as a result, they have no supporting documentation. And as a result, they have to pull that thing out. They can't include it because they know the union reps are going to come in and say, no supporting documentation. You can't support the complaint. The complaint's invalid. And so basically what they do then is, what I think they're doing in this case is simply saying, well, since we're not able to use it, we'll just deny it exists. And we won't produce it. Because the simple fact that that's what happened is a point in Mr. Maxwell's favor. That they didn't even follow their own procedures and taking the actions that they were doing, and they don't want that to come out. I really do think that we're going to run into more and more of these because during the years when the budget was fat and money had all over the place, you look at things like the Sunshine Ordinance requirement that they provide electronic information and update their systems and all that, and they didn't do it during the time when there was plenty of money. Now there's no money, and how much worse do you think it's going to get? I basically think that what departments do is instead of coming forward to you, which is, I think, disrespectful to you and to the whole Sunshine procedure, and saying, here are the documents, we're not going to produce this because of this, we're not going to produce this because of this, they simply go, oh, I don't even know whether the document exists. And I think we saw a similar case with Ms. Sang, where there was a complaint against her property, and common sense just says, yes, they must have some procedure to support that complaint, or else anybody could just willy-nilly file a complaint against somebody with absolutely no proof to support it. And then they look back and they realize that somebody who wasn't paying attention or intentionally just went ahead and filed a complaint they weren't legally allowed to, didn't have the support and they realized they were in a bad position, and so then they try to go, oh, well, there's no document that exists. And then Mr. Smith comes in and he's, anytime, he came in 3 times and said, I don't know whether there's an actual complaint form. I don't know whether they have to fill anything out. I don't know what our policies is. If he honestly wanted to go show good faith, he would have gone back and said, yes, we have a policy. It says they're supposed to do this and this and this. And I found out that it wasn't done.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion? We have the roll call, please.
Yes, Mr. Chair. On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Aye. Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Okay, this matter is referred to the Compliance and Amendments Committee. And on the previous item, 10054, Hearts Against Library, that matter is referred, I neglected to say this before, that matter is referred to Education, Outreach, and Training. Okay. At this time, we will take public comment for items not on today's agenda. Is there any general public comment?
Hello. Unfortunately, it seems like I'm going to be up here chastising you guys every public comment section that I get. Yes, I have very much public comment about the way this procedure is set up, to give false hope, to not provide logical, explanatory things to the people whom I believe you guys are supposed to defer to, the complainants. The entire process stinks to high heaven. This has been going on for 10 years. I've been in front of you guys with many determinations in my favor. Nothing ever changes. The monkey farm goes on. Some pigs are more equal than others. But the reality is that not only is this not a perfect world, but it's a lovely illusion. And for that disservice and everything that you do to us human beings, us citizens who come before you, I find distasteful, revolting, and to be non-accountable to the people you're supposed to be to, I think hypocritical.
Thank you. Is there further general public comment?
Good evening, Thomas Piccirillo. Sorry. First, let me say that, I noticed Mr. Schneider just walked out the door. I think that's disrespectful, and I think that the task force members should be seated when the public speaks a public comment. So, to Mr. Schneider, I say, shame on you. Secondly, I'm disappointed that Mr. Grossman did not show up tonight because, his memo...
Excuse me, sir. I believe Mr. Grossman has, in fact, joined us. Please continue.
Oh, great. Then let me move on. I did read the memo by Mr. Chafee. I don't think that the task force has descended into travesty and farce. But I think that the task force perhaps needs additional tools to achieve the objectives of the Sunshine Ordinance. It seems like every month you have the same complaints on your agenda. There is no final resolution of any of these complaints. There's got to be a better process that if there's a violation, then there has to be a remedy. But to have the complainants come back every month and to give the same testimony does not achieve the objectives of really what the Sunshine Ordinance is about, and that's open government and getting public records. Thank you.
Thank you. Is there further general public comment?
Hi, Deborah Benedict. And in relationship to that, not to seem a little disparaging, but the Joint Legislative Staff Task Force on Government Oversight said that the California Public Records Act, which of course the Sunshine Law is connected to, contains no meaningful enforcement measures. So probably not surprisingly, since there's some connection between them, there really is not a lot of teeth in the way the Sunshine Law goes through for enacting some kind of inducement for public officials to produce documents when requested by the public. So thank you.
Thank you. Is there further general public comment?
Yes. Peter Warfield, Library Users Association. There's a great deal of comment to be made. First of all, with respect to enforcement that previous speakers have referred to, I think that I have said this before. This body has in its arsenal of possible activity the preparation of reports and the making of publicity with respect to what's going on. And I believe that this body used to have a long time ago a web site that talked about, in ordinary terms, not through minutes, but in press release, story form, what it's been doing and what the rulings have been. I think that this body could do a great deal to help the public by essentially shining the light of sunshine on what you yourselves have done, decisions you have made, rulings you have made, and so on, and violations you've discovered, and putting those out there right out front, not buried in some document, but out on your website. You may be unhappy to know that the result of the difficulties with the, to put it mildly, with the Library Commission President, Jewel Gomez, violating the law was that the Ethics Commission came out with a letter. I don't know if you've discussed that here and talked about her failure to behave in essentially a decent manner. Her punishment evidently came from the mayor. She was reappointed to the Library Commission, and for further punishment, she suffered the re-election as president by that same Library Commission. And I think you have every business to discuss that and make a report about that and express yourselves to the public as well as certainly to the supervisors. James Chafee does have a letter that he handed out here earlier, which I urge you to put into your documentation of the meeting, about 5 o'clock public comment not having been held previously and his concerns about that. I'm disappointed that I had to call out for public comment to be heard on item number 2. I am glad that the chair did acknowledge that public comment needed to be called and had it. But those sorts of lapses, I think, give an unfortunate message to the public. I have unfortunately been here in tougher times when repeatedly public comment was forgotten or ignored to be called. I think that we've seen today something that I think is a big problem, and that is clarity about the procedures for testimony. The business about does somebody have something on behalf of the person presenting a case has to be more clearly explained orally as well as in writing. If you testify then, presumably you can't make public comment. And that needs to be clarified as well. I'm glad Mr. Grossman is going to speak later. I think that other members of the public, and maybe what I've suggested would be useful in that, is to ask the public and give opportunity for the public to say, how is Sunshine working for them? Thank you.
Thank you. Is there further general public comment?
Ray Hartz, Director, San Francisco Open Government. There are a number of issues that I think really need to be considered when looking at some of these cases. Number one, the boards and commissions have a tendency to make all the decisions and decide all the policies and determine everything that's going to go on or not going to go on. And then when it comes down to explaining or having to justify what they're doing, they send a commission secretary who is their employee and put them in the position of trying to explain away something that they had no part in doing. And, you know, when a member of a commission or a board steps in and stops somebody from making public comment or does some other thing under sunshine, I think that it is a real lack of moral courage to refuse to take any sort of responsibility for that, to show up and say, look, I thought what I was doing was the right thing, and maybe I was wrong, but I did it in good faith. Instead, they send somebody else who then has to justify their behavior. And I think that's an untenable and rather cowardly set of actions and a cowardly thing to do to somebody that is your employee. Say, now, go out there and defend our violations or our variations from the law because we don't want to go do it. I think it's rather, it was something I would never do, and it was something I would even question if I were on a board or commission and somebody else wanted to do it. I would say, why are we sending this poor person to stand up for us? Haven't we got the courage of our own convictions? Can't we take responsibility for our own actions? What kind of a message does that send? I come here with some of the cases because as I started over the last year, especially attending a lot of these commission and board meetings, I watched members of the public repeatedly have their rights violated. And even though it says on the bottom of all the agendas, know your rights under sunshine, a lot of people don't. And a lot of people, when they start to look at it, were just as confused. It's taken me 4 years to get to the point where I am. And so what I look now for is cases where repeatedly I see violations of sunshine and people who simply would rather walk out and talk about how horrible government is and how corrupt it is. And I think the only way we deal with those issues is to come out openly and use procedures and boards like this to deal with them out in the open so that that can be dealt with. I've said this before, and I'll say it again, that sometimes, especially with the California Public Records Act and sunshine, this is really the long form application for documents. Because not only do you have to go through whatever process and Durham and Strang they run you through, then you have to come in here and put up with a whole bunch of things where I would have to say 75% of the time they never walk in here and say to you, we withheld this document because. They come in and talk about the person's character and how unreasonable they are and how hard they've worked to do it. And I'll be honest with you, I would never do that for one fact. I'd feel I was pointing out my own incompetence.
Thank you. Excuse me, Mr. Hertz, could you just have a quick question?
Sure.
In terms of the sections in agendas where it says know your rights under sunshine, do you find that there are any parts of that section that are not clear that could be perhaps better, more clearly written?
You mean as far as the actual notification in the...
Yeah, where it says know your rights under sunshine. You're saying it takes a lot of people some time to figure that out. Do you feel that they are not clearly written?
I think that there are limitations of what you can put in, obviously, but sunshine is a long law,
right?
A long ordinance, and what is there, I think, goes over a lot of people's heads. They it's part of it. It's just a boilerplate now that is put on the end of the agenda, and I don't think most people really understand what that is.
Okay.
And as a result, that's a problem. The second thing is I've also seen a tendency lately for the city attorney's office to use something which I've seen them use now repeatedly, which is that a body is not enumerated in the charter. And I'm saying, so what is this? Equal justice under law. You go to one city board, they're enumerated in the charter, so the sunshine ordinance applies to them. But if you go to another city body, and they're not enumerated in the charter, it doesn't apply to them, but they still put it on their agenda. And then when it comes down to an actual case, they seem to be able to have the attitude of, oh, we can just pick and choose which part of it we want to follow.
Okay. Thank you. Is there further general public comment?
Good afternoon, President and Commissioners. Anonymous tenants here. I just want to say last week the hearing started at 5 o'clock, and this week it's 4 o'clock. And if I didn't check the website, I would have been late. I would have been here at 5. Thank you.
Okay. Further public comment? General public comment? Okay. Yes, sir.
I think I definitely believe some of the solutions are not excessively hard. What I want to do is make a parallel between another document that I have and like what you're doing. So I think one, for me, it means that you need to go back and review and talk about your 2011 draft update of the Sunshine Ordinance. The other thing, too, is I'm going to point to Section 2304 under the Shelter Monitoring Committee. And pretty much I'm going to 20-304, number B, under reports. And it says, the committee shall submit quarterly reports that shall include, but not limited to, information on the following: safety and shelter cleanliness and shelter disability access, et cetera, et cetera. And then there's another part in there where if they feel that something is so egregious, they could submit a emergency report to the Board of Supervisors. So I'm thinking somewhere along the line, you know, you're having some of the same problems from the same people. You need to take it up with the board and, you know, start demanding some type of action.
Thank you. Is there any further general public comment? Seeing none, general public comment is closed. Task force members, I've received a note from the respondent in item number 12. That would be items 12 and 13. He has to leave at 6:30. So is there consensus to move forward with that item at this time, or do we stay with the agenda? Member Kneber?
I'm always reluctant to change the order. It just ends up opening up everybody wanting to change their spots, and again, it's, you know, people are required to respond, and unfortunately, we have a long agenda.
Okay. Member Chan?
I think we should ask the public if it's okay, right? The consensus of the public.
Is there any objection within the public to moving item 12 forward, or any support for that?
Hi, my name is Deborah Benedict, and I have item number 5. So if these other items are taken before me, I will be spending a lot more time here, and this is my 3rd time coming without being able to speak or be heard. And I am disabled. I have a condition that makes it difficult for me to sit or even stand for long periods of time, so that's why you see me getting up and moving around. I would prefer not to have to go through the extended period of time of other people's things because of some inconvenience that it creates for someone who has another plan of action for later this evening.
Okay.
So while I do respect that people have things to do, I'd prefer not.
Thank you.
Thomas Piccarello again. I think it's bad policy to allow people to jump over on your calendar. We're all busy. We all have a lot of things to do. I mean, I could be home listening to the State of the Union address. But I'm sure most of the complainants have a reason why they want their matters heard at the time that it's set for. So I would encourage you not to allow people to jump on your agendas. Thank you.
Okay, thank you.
Peter Warfield, thank you for asking the public. While I'm sympathetic to folks who may have other things to do and are concerned about how long they have to wait, I came here at 4 o'clock an hour and a half ago expecting to hear the presentation by Mr. Grossman, which I hope that you will take up next as your next agenda item because you didn't take it up at the time that it first came up. That was my main purpose for coming here. So I hope that you will take that up next and would have to agree with the previous speakers, in particular the one concerned with item 5. Thank you.
Thank you.
Good evening. I support the no change unless it's an emergency. I'm usually last a lot of times, and I have to wait a long time. Thank you.
Thank you. public comment. There is no further public comment.
Well, for me, it's just more of, people being unclear of the policies and procedures. If you have an appointment or something at a certain time and 7 days before, you can ask for that meeting to be rescheduled. So it's for me, it's just somebody not understanding policy and procedure.
Okay, thank you. Further public comment? Public comment is closed. Mr. Grossman has joined us. Mr. Clerk, could you please call item number 1?
Item number 1 is presentation by Alan Grossman on the 6-vote majority requirement and its impact on complaints and other matters heard by the task force.
Mr. Grossman, thank you for coming, sir. Because we have invited your testimony, you are not limited to the usual 3 minutes for public comment. So please make your presentation.
First, I want to apologize for coming late. I thought the meeting was at 5 because the last time I came to a meeting that was supposed to start at 4, it started at 5. So in any case, that's my apology, and I want to also express my appreciation to the chair and the members for allowing me this time. As the agenda indicates, this is about the 6-vote rule and the fact that there's only 9 seats filled at the present time. Actually, at this meeting, there's only 8 of the 9 members present. I think to make you understand at least the way I look at this, I have to go back to this 2 laws that we're talking about, the California Public Records Act and the Brown Act, and then the Sunshine Ordinance overlay. Every record in the state of California is a public record if it contains information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. So this notion, whether a record is public or not, forget it. All those records are public. The only question is, are they disclosable? The same thing with meetings. They talk about a meeting. It's a congregation of a majority of the members of a legislative body at the same time and location. Okay? To hear, discuss, deliberate, or take action on any item within the subject matter jurisdiction of that body. That's what a meeting is. And they, of course, have to be open and public. So, what about this 6-vote rule? Well, what it does, it stacks the cards against the complainant. It's certainly contrary to the public rights of access, which are guaranteed in the Constitution, and, in my view, the laws that apply. But I'm not going to take you through how it came to happen that you 8 people have to have 6 votes in favor of the complainant, that's 75% majority, in order for the complainant to prevail, whereas the respondent only needs 3. Something wrong there. In any case, you have the same issue on quorum, too. Needless to say, if there are only 6 of you here, then the complainant would need 100%, and the 6 would constitute the quorum. In any case, I went back through the meetings of last year and the first 2 of this year. There were 16 meetings at which complaints were heard. Today is number 17. There is no meeting at which all 11 members were present. So by definition, the complainant needed 60% of the vote. When there was 10, 66 2/3 when there's 9, In this case, 75%, because there's only 80 people here, members, and it goes down accordingly. So we know there's something drastically wrong there. I'm talking 17 meetings, not one meeting where all 11 members were present. So how do we fix this? And what's the rationale for fixing it? Well, when you look at section 67.21E, which sets out the roadmap for what you do when you hear a complaint, it says when a petition, not a complaint, when a petition is filed seeking disclosure of a public record, not is the record public, but disclosure of a public record, the task force is to determine whether the record is disclosable. That's logical. It doesn't say, however, who has the burden of showing whether an exemption applies or not. So the requirement that the petitioner prove a violation is unnecessary, and so is the need for a motion to find no violation. That's also unnecessary. All you have to do is decide, is the record disclosable or not? And that really means, is it subject to an exemption? Well, going back, all public records in California are presumptively disclosable. And the city officials, departments, and policy bodies have the burden of showing that a specific exemption applies. That's in the California Public Records Act, and it's in the ordinance. So my suggestion was we got this backwards. Instead of saying, is it disclosable, what we should say is, does the exemption apply? That's the determination you have to make. So, when a motion is made by Mr. Snyder, is this public record, excuse me, the respondent has to specify what exemption applies, because that's also in the law. You can't say it's exempt. You have to identify it. The motion then should not be to find a violation, but rather the motion put to the vote should be for a determination that the specific exemption relied on by the respondent applies, and if it does not, the record must be disclosed because it is presumptively a public record to be disclosed, period. End of story. So what we have done is a simple procedure, it seems to me. When there are 5 aye votes to 1, in the old procedure, the complainant loses. If you flip it and you say, does the exemption apply, and the respondent only gets 1 vote, the answer is it's disclosable because the exemption doesn't apply. Now that sounds pretty easy, okay? Well, not all violations necessarily are public records issues, so you have kind of to deal with those a little differently. But I think it could be framed in a way that would make that possible. So the main thing is with eight people sitting here, 8 members, on any motion you could have a 4-to-4 split. Well, then who actually wins on that split? Well, it depends what the motion is for. Because if the motion is, does the exemption apply, and you can't pass it, then the presumptive character of the public record is paramount. It's disclosable. Under the old rule, finding of a violation, if there's a tie, nothing happens because you don't find a violation and you don't find a no violation. So this approach will solve that problem, and it will rectify what is really, really a rule which makes absolutely no sense in the context of what the task force does or what the rights of the citizens are to access the public records. So I've got a lot of stuff here. I know you allocated either 15 or 20 minutes to my talk. But I think there's a lesson in all of this that You know, I'd be happy to answer questions on how this motion practice works, but I think it's pretty simple, actually. Bruce?
Member Wolf.
Yeah, if we can maybe use your time wisely where we can ask questions in between instead of waiting to the end and not having enough time for us to ask you questions,
Sure.
if that'd be preferable. I'm just wondering, based upon what you last said, are you saying that instead of trying to find a violation, that maybe the intention or the semantic of how the motion is stated is just backwards? Did I get that right?
Actually, there's nothing in the ordinance that talks about your job finding violations or no violations. All it does is say you make a determination about the record, whether it should be disclosed or not, period.
Right. So the question maybe should be, does the exemption apply?
That's right.
Okay. Rather than if there was a violation. It kind of sounds somewhat like how we determine whether the case actually is within our jurisdiction or not. We're not judging the merits of the case.
Well, you
exactly.
are on the applicability of the exemption because, as we know, there are a whole range of exemptions under the California Public Records Act, some of which the ordinance eliminates and some of which are effective, and there's even one in the Health and Safety Code, which I'm sure very few people know about, but it protects the disclosure of plans filed with the Department of Building Inspection. But they have to assert it because it's a public record.
Member Snyder, Member Johnson.
Mr. Grossman, thanks for all this work. It's really interesting, and I think you've come up with an interesting and really clever potential solution. I think there are a lot of questions that could be raised by the shifting of the burden in this way. For example, what would we do in an instance where the respondent isn't claiming an exemption, but is rather saying the records don't exist or we've given them everything we have? They're not asking for, they're not saying there's an exemption, so how would we, if the question is does the exemption apply, that's a question that can't be answered in a scenario like that.
Well, if there's no public record, there's nothing to disclose.
Right.
In the first place.
Right.
How do you prove the non-existence of a public record? You're a litigator, you tell me. I don't know. I would just say somebody under oath says we've searched all of our records and we cannot find any record.
But then what's the question we're answering? And what's the question? What is the question that a motion addresses in an instance like that?
Well, the motion actually doesn't address that because the complainant has to allege that the records exist, which is a different question.
Yeah.
Because there's no exemption that need apply. If the department respondent says we don't have any records, and the complainant says you do, then
the question,
the respondent cannot prove the non-existence of its records.
And
all the complainant can do is try to prove that they exist.
But all that we would be left to decide is whether there's a violation or not.
There's no room for a violation only if they claim there are no records and they exist, in which case they become immediately disclosable, presumptively.
But see, the question changes in that instance. We would have to come up with a different question. Whereas now, the way it's set up, the question that we're asking when we decide whether to have a motion or not is there a violation? And that applies across the board to anybody that comes before us. What you've proposed is the question rather is there an exemption which applies here? And I think it's very clever, and I think it fits many circumstances, but it doesn't fit, so we'd have to ask a different question depending on what the facts are before us, which I think is problematic.
Okay, I don't think it's all that clever, to be honest with you. I think it really is the way it should have been in the first place. And somebody went off the tracks somewhere way back when, and I can give you some suggestions on who helped it along, but that can wait till later. But the point is that if I've been coming to many of these meetings, and there are very few where the issue is do the records exist, to be honest with you. I mean, if you just look at the 10 records cases you're hearing today, I don't know how many of them involve do the records exist. I think in one case they said they don't have them, in which case what do you do?
But there are many, including today, where there's no, I think today, where the respondent isn't asserting any exception because they don't say anything. What do we do with that?
Personally, I think if you look at this and say, well, we're not sure how we handle something else, which happens occasionally, and decide, well, because we can't do that, we shouldn't try to fix the problem that is most prevalent every time you meet and look at these complaints.
Yeah, no, I agree. I agree there is something inherently wrong about the quorum rules, and I wish there were a way to fix it.
I'll help you with that in a minute.
All right.
Member Johnson, Member Washburn.
I think this is a brilliant and very flexible proposal, and this may help Member Snyder's question, but I think it would also cut down on the amount of time we spend discussing, because if someone doesn't claim an exemption but they haven't turned over the documents, we would immediately ask them, why are you not, what is your basis, which is also in line. We would ask them what exemption they're claiming for not turning them over. But then my question for you is to carry that out a little bit. I know we have a problem with enforcement when we do send things to ethics, but would the reasoning then be along the lines that if we found the record was disclosable and we gave them the order of determination saying you have to turn it over, if they didn't then turn it over, that's when it would possibly be referred to ethics based on that?
Well, that's the way I view it. In other words, the order of determination would be there's no exemption that applies, period. Automatically then, that record is a fully disclosable record, and they have 5 days to disclose it. If they don't do it, it comes through the process, back to ethics. They claimed an exemption, it doesn't apply, we've ruled on it, we've heard it, end of story.
Okay.
It's a lot simpler, actually, because the Public Records Act and the ordinance really do drill down on the need for the respondent, department, or official to identify the exemption that they're relying on and to notify the requester within a certain period of time what that is. And so the facts become narrowed, actually, quite a bit, because all you know is there are public records, they haven't turned them over, they claim this exemption, and then the whole discussion before you is that exemption, period. And what it does is it also, because, in my presentation, the written part, I talked about the problem that the average person has in getting records if the department or the official won't turn them over. The Public Records Act does not give you any remedy other than go to court. This is the forum, the people's forum for getting those records and fixing problems in the way meetings are conducted. And the ordinance was designed to make it as easy on the person who needs the records to get the job done. Just read it. The people who were writing it did that. That was their whole purpose in doing it. They don't have to find a lawyer. They don't have to, pay a lawyer. They don't have to go through the court process. They certainly don't have to take on Mr. Threet and his 199 colleagues over at the city attorney's office just to find that they are entitled to records. That's what I had to do to get the ethics records. I had to find a lawyer. I had to do a lot of the work myself, and it took, believe me, a lot of time. That's my point.
Member Washburn, Member Knepper, Member Snyder.
Yes, Mr. Grossman, your flipping of the switch is just simple and elegant, and I wholeheartedly support us implementing this. I also want to say that I think that we need to do something about having voting on anything having to have a majority of our full complement of members. That's a problem because we have other matters regarding public meetings that come up. And in reading your document, I was wondering what are your thoughts on how to fix our quorum problem for those matters?
I actually do, because the reason you have them is because the city attorneys advised you that those are the requirements. If you don't accept that advice, and I don't, of course I'm not sitting where you are, then you can adopt your own rules, which they've done in Oakland, and they do in other places in this state. Other policy bodies have different rules. The vice here is this litany of the charter is superior to the ordinance. That's wrong. That's wrong. That's clearly wrong. The second is you're part of the executive department under the mayor. I don't know if you knew that. But according to Mr. Owen, one of Mr. Threet's colleagues, you're definitely part of the executive department. You need to get your budget straightened out. You better make sure that your department runs well. There's all of these things that you're supposedly doing. Well, that is just silly, because we know the only time the mayor is even mentioned in the ordinance is, I think, in two places. One with calendars, and the other is the fact that he has to help provide some support for the task force. But you're not part of the executive department. You're not part of any department. You are a standalone, independent body created by a voter-initiated and voter-approved law. And it comes under the umbrella of the California Public Records Act and the Brown Act. And that's where it comes from, not from the charter, not anywhere else. So if you decide you're not part of the executive department, you can probably make your own rules.
Member Knebber and Member Snyder, I believe, and Member Wolf.
Finished?
I just wanted to say I wholeheartedly support an effort to make our own rule here and stop this practice of having to have 6 votes to pass anything. I've been just really disheartened with some of the decisions we've reached because of that.
Okay. If I have just 2 or 3 more minutes, I'd like to cover something else because I think it's important. I think everybody pretty well knows that I don't get along with Mr. Herrera's office. No mystery there. But I think that there is a dichotomy that exists between what the city attorney says to the public and what the practice actually is. And we know what he says to the public. I have it here somewhere. Oh, yeah. This is what he says right in the introduction of the Good Government Body. A public office is a public trust. As public officials for the city and county, it is our highest responsibility to conduct the functions of government in a way that is honest, open, and responsive to the citizens we serve. I am proud to offer my office's unwavering commitment to assist in that endeavor. And then there's another quote in which he encourages his clients to embrace the aspirational spirit of openness, transparency, and accountability that animate them, the principles of open government. Well, that sounds pretty good, right? Well, that isn't the way it works out, though. So I took 2 examples. One is in the Good Government Guide itself. And what it says is, effectively, and I have it here, I could read it, city officers and employees should be aware that legal advice on ethics laws and open government laws may not be confidential. Of course they're not, because the ordinance makes it clear that they're not. So, any written legal advice about conflicts or open government laws may not be withheld from disclosure if there's a public records request. Accordingly, the practice of the city attorney's office is to inform any officer or employee who requests such advice in writing, that the advice may be subject to disclosure upon request by a member of the public. Now, what is he saying here? He's saying, we're going to give you oral advice. There's no record, right? So that we're going to encourage you to do that. Of course, that will undermine a bit of the openness that we're talking about, but, a little bit here, a little bit there won't hurt. But, I don't know if Peter's still here. This, to my mind, is the most blatant example of what the city attorney's real practice is. And as you know, under the ordinance, city attorney has this restriction. I'm sorry, it's both a mission and a restriction. It shall protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public record for the purposes of denying access to the public. That's pretty serious stuff. And then the letter section says the assigned attorney, that would be Mr. Threet in this case, shall act solely as a legal advisor and advocate to the task force, which means they're not just advisors. They've got to advocate in its mission and what it does. That's what I'm doing too. So Peter Warfield, who's sitting back there, filed a complaint against the city librarian in 2007. He actually filed two complaints seeking certain library donor records. So as a result of a public records request that I made after the whole procedure was done and finished, I obtained records that showed that beginning on August 10 of 2007, when the librarian's office sent one of Mr. Threet's colleagues, Deputy City Attorney Gessner, a copy of the first request, through December 24th, that would be about 4 months, there were 17 email communications between the librarian, that's Mr. Louis Herrera, and his staff, and Deputy City Attorney Gessner. And during that period, Deputy City Attorney Gessner authored several responses to Mr. Warfield and to you, including a 9-page legal response to which he added the following, and this is what's really important. She's telling, I believe, Mr. Herrera or Ms. Blackman, as you know, this matter is scheduled to be heard by the task force 1 week from today. I'd like to meet with Sue, that's the person who actually testified, and whoever may be accompanying her to the hearing to go over the issues and prepare for likely questions from the task force. Please let me know a time you'd be available to meet either this Friday or Monday. Well, let's see, what did the ordinance say? Shall not assist? I mean, how blatant could you be? And then at the end, when you finally entered an order, she says, so all things considered. Now she's writing Herrera and Blackman, and she says, so all things considered, it was not a complete defeat. And interesting, now she's the cheerleader, we didn't really lose the whole game. They did not order the library to start posting grants. I'm drafting a response for Lewis, again, the librarian, regarding the disclosure of home addresses. Okay, so I don't want to go through how you got to where you were today on the rule, but it has a lot of problems. My final thoughts, and then I'll leave you. In all honesty, based on my own experience, I don't think the public or the task force is getting an honest count from the city attorney and its lawyers. I don't think they're doing their job as an advocate. I don't think they're doing their job staying out of the helping the city departments aspect of it. And I've seen the written advice on these issues that brought you to the 6-vote rule. And I don't see that they've ever done a serious legal analysis of them, because if they did, I think they'd end up with me, because that's what I've done. And the second one, I mean, that would be the first and the third. And on the second one, Mr. Owen's memorandum, surprisingly, doesn't even mention the Brown Act. And that's the one that says you got to have 6 votes. So, I mean, I don't want to go through the whole thing, but, you know, my views are you either get a fair shake from the city attorney, which you're not getting now, and it's not I'm not disrespecting Mr. Threet, because this happened long before he started. And I think you ought to try to get an outside opinion on all these issues from a law firm that doesn't have any political stake in what it tells you. And then, of course, as I've said repeatedly, you can always decide you don't, I mean, you like the city attorney, you like Mr. Threet, but you don't have to follow its advice. And you should do your own thing, which is what I think you were entitled to do from the beginning. The drafters of the ordinance meant something when they put that together. And one of the things they meant was this law is going to stand by itself. It's going to be supreme. And nobody on the outside is going to be able to attack it in some legal way. And that's where I think you can make your decision, that if you want to have a set of rules that make sense, if 9 members are seats are filled, a quorum is 5. 7 show up, a quorum is 4. Voted majority is 4.
Member Kneber, Member Snyder, Member Wolf.
I actually also like this idea. I also have a bit of a hiccup with the idea of the exception. I think that we can change that terminology that includes exceptions, or that the records don't exist. Like, maybe I don't think that it has to be only an exception. I think we can include terminology that says it's either an exception or they're claiming that the records don't exist. I think that we can work that out and make that included into that, because I do agree with Mr. Grossman that it's not as many cases, but it is something that's brought up, and I think it has to be addressed. I think that we can massage the terminology to be able to include those two. What do you think about that, Mr. Grossman?
Member Snyder, Member Wolf.
Yes, so just I do think there's a problem with our quorum rules, and I am in support of finding a way to change them. You know, the more I reflect on the idea, Mr. Grossman's idea of sort of shifting the burden of proof, the more problems I keep thinking that raises. It essentially makes any complaint that comes before us a presumptive violation. And I understand your argument about what the California Public Records Act says, that records are public unless an exception applies. But all of the case law, and as far as I know, the litigation in this area, exceptions are like affirmative defenses. Somebody who alleges a violation has to show the violation. And the public agency that says there was no violation can assert these exceptions kind of as affirmative defenses. And for us to sort of turn that on its head, I think would raise a lot of problems in terms of being consistent with California adjudicative bodies, with our ability to cite to case law. Anyway, I think it raises a lot of problems. What I do see in your memo is the possibility that we have a Brown Act argument that a quorum is what I wish we could say a quorum was. And if we can say, look, the state law says that we can determine that a quorum is X, then it doesn't matter what the city charter says. I mean, I'm oversimplifying a little bit, but if we have a solid basis under the Brown Act to say, here's our quorum rule and here's why, I think we'd have a good chance at thereby making an argument that it doesn't matter. The question of whether the Sunshine Ordinance trumps the city charter or whatever, we could set aside and just say, Brown Act provides this, therefore we do it. That to me seems like the best leg to stand on, but I haven't looked at this issue in any depth, I should say.
Well, I want to point out to you what's in the ordinance on the presumption, which I referred to in the memo. 6721G, in any court proceeding pursuant to this article, there shall be a presumption that the record sought is public. Now, they use that language, public. What they really meant was is disclosable. And the burden shall be on the custodian to prove with specificity the exemption which applies. And that's all I'm saying you guys should do. The presumption is the record is disclosable. The respondent has to prove what exemption applies. The one he specified, not just any exemption. And I'm willing, I'd be happy to discuss this, ad infinitum for a long time, because I actually had quite a bit of other stuff to talk about. But it seems to me that the existing system doesn't work. How can it? How can somebody come up here seeking a public record which is presumptively disclosable, get 5 out of these 8 votes and lose? What is this? And if there's only 7, James Chafee isn't here, but he said something that really struck me as pretty important. He said every empty seat is a no vote, and every absent member is a no vote. It's not the reverse. So why should it be a no vote? It shouldn't be a no vote. It shouldn't be an aye vote. It should be neither. So even though the city attorney says those 2 seats vote no, I can't get my head around this phantom maybe voting yes at some point. It's just too wild for me to understand.
Member Wolf?
The question of whether absent members, whether a vacant seat or not present at a meeting is a no vote or not, is questionable. I mean, in most deliberative bodies, most people would say if there could be abstentions go to the majority, because those people are choosing not to vote. So whether all the vote, what makes the case for it be those people being no votes is that we're required to have a certain number of people be present. So that's where I understand. But I just want to be clear that if we were to go by the rule of whoever shows up, if we have enough people here, then we have a quorum. And if some people leave and it doesn't drop below half of that, then we still maintain a quorum under standard Roberts rules. Then at that point, yes, any abstentions or absences would go towards the majority. But I agree with you. In this case, when we are obeying or we are following a rule of we have to have this many people, I would agree with you that those absent is to a deficiency of the complainant. Where there would not be a sunshine ordinance, the state law applies, as it does in the majority of governments in the state of California. Thus, if their city charter were to diminish the requirement of greater or more expedited public access, their city charter would be in violation of state law. And I would hold that the Sunshine Ordinance at that point is an extension of state law, because it can only be based on the state law, and it's given the authority to create more public access than what the current state law has. So I will agree with you on that comment. My last point is on us being quasi-judicial in relation to Member Snyder's supposition. we're not a court of law. We're not required to follow court procedure. It is something that we look to do because it seems like that is a proper way to do due process. And it seems like because we are quasi-judicial that we would want to give the fairness of that. But we have our own procedure. You won't find this procedure in a court of law. It's not the same thing. So complaints that are made are not just accusations. They are, I didn't get something. And the law says that all these documents are supposed to be public, but I didn't get it and I asked for it. It's not up to the complainant to make the case. The complainant is just saying, I didn't get this. It's up to the respondent to make the case as to whether they are exempt from the Sunshine Ordinance or not. That's why we don't call them plaintiffs and defendants, where defendants don't have to testify in a court of law. Here, a respondent must say why they didn't produce it. So I agree with you in that factor, and I would frankly say this body can go about its business any way it wants and wait for a response from somebody that we're either doing it right or we're doing it wrong. And it could be a city department or what have you that says they're doing it wrong and we continue to do it right, and they can take us to court if they want. I mean, we can reverse it. Instead of us saying, let's go find a decision, let's make a change, let's do it, and then let's see what happens. If the city, the board of supervisors, the mayor, the city attorney wants to balk and they want to do something, what is the procedure for them to stop us from what we're doing? They can't just disband us. The voters are the ones that put us here. So I'll leave you with that.
Well, I just want to make one comment about what you said right at the beginning. You've not had a meeting with all 11 members, at least in the last 17 meetings where you heard complaints. And I think you've only had one where there were 10, but you would still need 6 out of the 10. So during all that time, a simple majority was never available to the petitioner. So there's something basically wrong with that. And I think there's something basically wrong with the idea that when you pile all of this stuff, A, the charter trumps the ordinance, B, you're part of the executive department, and therefore you need to have the 6-vote rule, and then C, vacant seats, vote no. What do you end up with? You end up with this monstrosity, which is so unfair, and actually, I think, violates the constitutional provision, Section 3 of Article 1 of the state constitution. The public access to meetings and records is a constitutional right. And the interpretation of every law should be skewed to make that happen.
Yeah, I have just a couple of things I wanted to say. First of all, Mr. Grossman, big thanks. Your thoughts are certainly well worth taking into consideration. Second, I do want to continue this discussion, and what I would like to do is reconstitute the Rules Committee. I will be sending out an email to my task force colleagues for volunteers for a Rules Committee so we can pursue this matter in some depth and some detail. Mr. Threed had some things he wanted to say, then I will open it for public comment. Mr. Threed.
Through the chair, Jerry Threed with the City Attorney's Office. There's a lot of things that I could respond to, but I think I want to keep it simple and just focus on a few things. And I'd like to start with some agreements with Mr. Grossman on some issues. It is true that the City Attorney's advice is advice to you, and you may follow it or not follow it as you choose. In connection with that, I would also just note that the oath you all take as task force members, you do swear to uphold the laws and do your best to understand those laws. So my advice to you is designed to, as the best I can, explain what those laws require. I may not always be correct, and Mr. Grossman may be correct. I can't say that that would be up to someone higher than both of us to decide possibly in a court of law. And I want to also say that I don't have any quarrel with Mr. Grossman's description of the presumptions of the laws involved here. The presumption is that a record that fits the criteria Mr. Grossman laid out is a public record, and the burden is on the respondent in a court of law to prove that there's an exemption that applies, and there would be no quarrel, I think, with having a similar presumption here in the complaints that come before you. But I think where I would have to differ is I think that confuses that issue with another, which is that the ordinance requires that the task force reach a determination and communicate it to the complainant within a certain amount of time. And in order to reach determination on a complaint before it, the task force must take some action. And those actions typically are through its motions. And the task force not only has motions to find violations, I've heard motions most recently at the last regular meeting to find no violations. So whatever the motion is, the motion requires, under the advice that has been consistently been provided to the task force, 6 votes. And that advice is not some whimsy that the city attorney has come up with. It's based on very solid analysis, in that the charter is the constitution of the city, and an ordinance, whether it's passed by the Board of Supervisors or whether it's passed by the voters, must be consistent with the charter. And the language of the charter does not make this task force an executive body. The provision in question speaks to the members of an appointed board, commissioner, or other unit of government. It doesn't say other unit of government that's a part of the executive. And it requires that a majority of the members approve any matter before that body. And it's been very consistent advice for all the boards and commissions of the city that requires a majority of the members that constitute the body, rather than a majority of those who show up for a meeting or a majority of those who are currently serving in those positions. And that was very consciously put in the last charter amendment that was also submitted to the voters and approved by them, to prevent a minority number of the members of a body from making decisions for that body. That's how it was explained. So, while I may differ in the conclusions, and our office may differ in the conclusions we reach about what's required here, it's not specific to this task force. It's not designed to frustrate the Sunshine Ordinance or the actions of this task force. It's based on what we believe that the law requires.
Thank you. Mr. Grossman, did you have?
Well, I understand what Mr. Threed is saying, and I don't want to pursue any extracurricular stuff that's going on right now that he and I are involved with. But I think that the members of at least the Compliance and Amendments Committee have seen my effort to demonstrate that between the enabling section of the California Public Records Act that authorized the adoption of the Sunshine Ordinance and the section of the Brown Act that does the same for public meetings, that between the Brown Act and the Records Act and the ordinance, the field is totally occupied, and there's no room for the city charter to restrict or in any way disable the operative provisions of the ordinance. And as I was saying, there were some pretty smart people who wrote that ordinance, and the supremacy clause is there for a reason. They must have thought it worked. Otherwise, why put it in? And I understand Mr. Threed's point. I mean, I've heard it over and over again that this is just an ordinance, but if you change the name from this, Sunshine Ordinance to the Sunshine Law, then they would say, well, the charter trumps every law. Well, we know that's not true. So you get caught up with the name, and you get caught up with this notion about a constitution, and the constitutional power of the city it doesn't extend as broadly as the constitutional power of the state or the legislature. It is limited to a certain area, safety, and I forgot what they are. Mr. Threet would know. But public records and meetings, it's not so clear. Not so clear at all. So you have the preemption issue, you have the supremacy issue, and those have never been, at least to my knowledge, looked at seriously by the city attorney's office, and I know why, because they might not get the answer that they want.
Okay. Mr.
That's
Grossman.
my opinion.
Again, Mr. Grossman, I thank you. Mr. Threet.
Through the chair, I don't mean to belabor the point, but I just want to note that I did make an offer to analyze these issues to the chair, and it was declined.
Well, I believe you explained at the time that the amount of time you can spend in dealing with task force issues is limited, and this might necessarily cut into the time that you had the total time that you had to work with us. So that offer is appreciated, and if the time constraints weren't there, I certainly would have said, yes, go ahead. At this time, I would like to open this to public comment.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I'd first like to address Mr. Threet's comment about how all this applies to all the different boards. I have been attending rent board meetings for the last 7 or 8 months, and they have 9 members, but only 5 of them vote. So basically, they decide everything by a simple majority. 3 votes yes and 2 votes no, it goes that way. And what they do is they play musical chairs during the meetings, and one person will get out and another person will come in. So I have a real question whether or not that actually applies to all boards and members. Mr. Grossman's comments about going to court. Well, there are enough people in this country who are denied fair justice and fair treatment by the fact that their only chance is to go to court, and they don't have the wherewithal to do that. And all it simply means is that the rich get what they want because they can afford the lawyers, or at least they can threaten to bring in the lawyers, where the poor unfortunately cannot. And I'll be honest with you, I think with a lot of the determinations that are issued here and in the Ethics Commission, I think city uses the fact that they believe that most citizens are not able to or willing to spend tens of thousands of dollars to take it to court, that they can just willfully ignore it. Even when you tell them they're in violation, they simply choose to disregard it. Going to Mr. Snyder's, or Member Snyder's comments, I think it would be a lot easier for the members of this commission to understand the distinctions in these changes than it would be for anybody in the public. I think the public clearly does not understand when I walk in and there are 6 people here and I got 5 out of the 6 votes, I lost. That they don't understand. So I think putting it in a court, putting the ball in your court and saying, well, if it's a little more complicated for you to understand how to phrase or put your motions or whatever, I think that's where the responsibility has to lie, because there's enough on the burden on the complainant or the plaintiff in the appeal process anyway. And lastly, the policy body decides these things, not anybody else. And the city attorney can say this, that, or the other thing, but I watch the rent board. They sit down there, they decide anything they damn well please. And they don't answer. In fact, they start their public comment with, members of the public may address us, but we have no obligation to consider anything you say in our deliberations. So it's basically, oh, yeah, we're fair. Now, we don't have to consider anything you say to us, but we're fair. And I think that has to be the biggest load of horsepucky I've ever heard in my life. The last thing I'll say is your own bylaws. Your own bylaws basically say that if any member misses more than 3 meetings in a 12-month period, then a recommendation needs to go to the Board of Supervisors recommending that they be replaced on the board. So getting the 2 places that are filled, and then using your own things, it's, hey, 25% of the meetings is a pretty generous miss factor. And we're talking versus you enforcing your own rules and following your own rules, but we're also talking about whether or not the public policy issues that this body directs itself to should be handled in a way that people are going to look at it and say it's done fairly and equitably.
Thank you. Is there further public comment?
Yes, my name is Deborah Benedict. I am disabled, and I am the organizer of the Chapter 16 of the Californians for Disability Rights, Inc., which is California's oldest disability rights organization. And I have listened to the incredible work and tedious detail that Mr. Grossman applied to the information that he presented before you here. And then, of course, the information about the fact that other task force, other individuals who are doing Sunshine Law have the ability to create a majority rules for the rulings. And I've also listened to Mr. Freed's argument, but with the documentation that shows that the city attorneys are actually advising individuals who come and speak there. I do not have an attorney. I cannot afford an attorney. There is no chance that I'm going to be able to get an attorney to stand beside me as I present my case. So as I bring things to you, I depend upon your fairness in giving me a hearing, and I don't know the rules of Sunshine. I expect that you as experts on that, in dealing with it all the time, will understand the slots that my information and the lack of access to records I've requested will fit into. So, you know, to have a conflict of interest where you have an individual who's advising you, who is also advising the people who are on one side of an argument, seems grossly unfair to the degree of being illegal. And so whatever decision you decide to make regarding how decisions are arrived at, I really am learning a lot, and it's not particularly encouraging in hearing the people who have experience with this board. I'm unexperienced with this board. I really am not an expert. I wish I were Mr. Hartz and had all the information about the House Sunshine Law and all the specifics of the ordinance. I don't. I am the member of public that they discuss. I'm a person who doesn't know about how Sunshine Law specifically works. I just know that I can't get information and I can't get a response from a public official. And I know that I deserve that. So ultimately, I have no place to go but to you. And so your decisions directly affect the ability for me to have what is my legal right, which is access to information from the city and members of the people that work for the city. Thank you.
Thank you. Is there further public comment?
Public comment. I am apparently the person they were talking about who had the 5 yeas and the 1 nay and still lost. Well, it's interesting because today I'm going to have a case heard. And initially when I filed this case, I notified the chair through the administrator, his helper, that the full board must be here to hear my complaint because I was screwed by false process, which the district attorney says, the city attorney says is allowable. Now, since the full board is not here, I want to hear from the 3 people who are not here, why they're not here, haven't been notified, and if I cannot hear from them, I demand that their votes not be counted and that I have due process, because that is exactly how the city attorney has circumvented my due process. Another thing that was commented upon by the gentleman earlier was the fact that he said that if they don't have a presumable piece of paper that's disclosable, they don't have it. We can't make them produce a piece of paper that's not disclosable. 10 years ago, I was denied emergency services at San Francisco General and came to this board to get a piece of paper that was required by law to be in the file that would have proven my case against the city and county, which was a medical screening. The other side says, we don't have the record. You guys ruled, well, we can't make them produce something that they don't have, when it was by law required to be there. They didn't have to sign and say, oh, we had to comply with the law, or that everything we produced was accurate and correct. Oh no, they could play a game with definitional meanings and words. But I am also the person who's coming to you years later with a signed confession after having the Inspector General take the city to court to find out that they had broken the law over which I came to you guys for specifically. So there can be a game played with them saying, oh, well, we don't have that record, thereby we don't have to supply it when it is legally required to be there. That has happened to me, so that's one thing I would like for you guys to consider when you change this arbitrary, malicious, incorrect law. In the meantime, like I said, I have notified you people about my case coming up at, which is 10071, that I demanded it be heard within the 45 days and that I be heard in front of the full board. I've heard testimony that the full board has never been here. I told everybody that if there was a problem and the full board was not going to be here to notify me. Why have I not been notified? How can you even raise your heads and consider yourselves human beings in a rigged system that you know is rigged? And my case and everything else proves it. Please, I'm waiting to hear from the 3 seats that are vacant. Tell me why your vote is no against me. I'm waiting. I'm waiting.
Thank you. Is there further public comment?
Peter Warfield, Library Users Association. I can only say that several of the members have used words about Mr. Grossman's presentation that just stole them right out of my mouth. So brilliant, elegant. I thought I could bring that one up. So I can just say, I think if you just do as Mr. Grossman says, everything will be fine. I think that's the basic message that I've got. I do have some other additional comments that dance around perhaps some of the issues that have been discussed. In the past, the city attorney not only drafted responses for the library and presumably others, but actually came to this body and argued cases against me as a complainant. My favorite instance of that was when the city attorney came and the head of the library came and the library commission secretary came, and I think there was a 4th person as well. And I believe the task force, thank you very much, found in my favor. Bruce Brugman, the publisher of the Bay Guardian, was appalled that the city attorney, despite what the law says about not being allowed to assist in the denial of documents, was in fact not only doing it, but doing it openly and publicly and arguing cases here. That, I believe, thanks to Mr. Brugman's interventions and pressure, led to the city attorney pledging that the city attorney would not, in future, argue cases in front of this body, and I believe the city attorney has stuck to that. But as you've heard today, everybody knows, and Mr. Grossman has proven, that the city attorney is drafting letters for the library, is encouraging the library, is advising the library, and who knows who else. And we certainly know that that's the case, even if the city attorney doesn't show up here personally. The oral advice hint is one of those wink, wink, nudge, nudges that's completely consistent with the city attorney making it such that it's difficult or impossible to find documents that are available for evidence. Certainly, I think you need to review the oral information portions of this ordinance to make it much more explicitly strong about oral information being required to be turned over upon request when it has to do with sunshine matters, when it comes to the city attorney, and oral information in general having to be turned over to the public, in particular on anything that is disclosable. There's a great deal more to be said, but as I, in summary, said, if you just do as Mr. Grossman says, I think everything will be fine. Thank you.
Thank you. Further public comment, please.
Good evening, President and Commissioners. I'm sure you guessed by now that I'm a terrible speaker, so bear with me. I support Mr. Grossman's accurate presentation 100%. However, I would like to point out, I do not mean to be any disrespectful to any of you, So don't misunderstand my presentation. I think all of you do a great job. The California Public Records Act, I will refer to it as the CPRA. The CPRA was created to provide the public access to public records. This CPRA is mandated by the state, and the Sunshine Ordinance is a spinoff from the CPRA, meaning Sunshine Ordinance must follow and adhere to the laws of the CPRA. In my limited review of the CPRA, I did come across CPRA section 6253E, which states the state allows an agency to adopt requirements and make access to public records faster, more efficient, or greater access than the prescribed minimum standards. I have not come across any law that supports more restrictive, less efficient, or lesser access to public records. In conclusion, the CPRA says we have a right to public records and greater, faster access is allowed. However, when you create a Sunshine Ordinance that requires you to obtain a minimum quorum vote of 6-0 to obtain a record, that does not give the public access whatsoever. This is contrary to the intent of the CPRA. The quorum vote must be changed. I don't believe the CPRA gives Sunshine Ordinance the right to determine if the public has a right to a public record. I believe you have the power to determine if the record is exempt or not exempt. In the California Public Records Act, under the heading Public Record Defined, number 1, identifiable information. The public may inspect and obtain a copy of identifiable records. Writings held by state and local government are public records. A writing includes all forms of recorded information that currently exist or that may exist in the future. The essence of the CPRA is to provide access to information. Not merely documents and files. However, it is not enough to provide extracted information to the requester. The document containing the information must be provided. So I hope that clears it up as far as information and documents. They're both we have a right to them. Also, tonight I would like to see a vote from the commissioners on Mr. Grossman's presentation on whether you intend to take some form of action and change the quorum vote or not. It would be very helpful to the public. Thank you very much.
Thank you. And just in response to that last comment, you'll note on the agenda it says discussion. It does not say possible action. However, again, this matter will there will be further discussion on this matter. I do intend to bring back the Rules Committee for that purpose, sir.
Thomas Piccarello again. I want to thank Mr. Grossman for his presentation and the task force for allowing him the presentation. I'm just not sure that this was the appropriate forum for that presentation. I mean, you do have committees, and perhaps it would have been better for the complainants who have been waiting to hear their matters for you to have a discussion like this at one of your committees. Secondly, I'd have to agree with the city attorney, though. You're all appointed by the board of supervisors, and most of you are journalists. You have no familiarity with the law. Whether or not you're getting good or bad advice from the city attorney, I think you want to follow his or her advice. You may be a standalone. I mean, you'd be created by voter initiative, but you still have to comply with the law. And I want you to comply with the law, whether it's state, local, or federal. So I agree with with the city attorney. You're not a person unto yourselves, and one final thing. You have failed in your responsibilities of filling these vacancies. I mean, you've had vacancies for a long time. Task Force Member Coffin, she did some good things, but she's been asking a long time. And you shouldn't let your friendships with any task force members impede this task force from having a full membership. And then you won't have the need for discussion of whether you need 6 votes or 7 votes. If you fill this task force with members who want to actually enforce the Sunshine Ordinance, there'll be no absences. So I urge you to, go to the Board of Supervisors, and the clerk. The clerk of the board actually has jurisdiction over you, not the mayor, right? The clerk appropriates monies for you. Go to the clerk's office and tell her the urgency of your lack of members. Thank you.
Thank you. Further public comment? Seeing none. Member Wolf.
I'd just like to make a comment on the last public speaker. One of the major reasons why we wanted to have Mr. Grossman make the presentation at the main meeting and not at a committee meeting is because if more than a quorum of the full body attends a committee meeting, then it must be deemed a full task force meeting. Thus, not all the members would have the benefit of Mr. Grossman's presence. So, the only place we can do that in a full quorum or in a full complement is here at a regular meeting. Could we have had a special meeting specifically for that? Maybe. Maybe that would have been a proper way to do it. But we felt that we disrespected Mr. Grossman at the last meeting because he came up and tried to do this during a 3-minute public comment period. And he felt like he needed more time, and a lot of us felt like we really wanted to hear it because the work that he does is really important. So I just wanted to say that in all deference. With regards to as far as our legal counsel here is from the city attorney's office, but there's a firewall. That person is our legal counsel. It's not city attorney that is sitting at the desk. It's the Sunshine Task Force's own legal counsel. It serves the task force. By the same token, Member Snyder, who is also an attorney, is a member of the bar, is required. We're required to have somebody on the board. And if there is disagreements, then that's an important factor too, as to what the counsel, the interpretation of law is, and that's the art of law. And I would just leave us with that thought. Thank you.
This time, the chair will declare a 5-minute recess.
The sheriff came up here after family because he brought food.
Shame on me.
Yes.
What are they?
Rice cookies or almond cookies?
You don't know what. Oh, good catch. What are they? I'm sure they taste good.
No idea. It tastes good. Coconut, some rice, crackers.
Good. It's definitely rice. It was just so funny. Cheddar Benny's came out.
I know.
You tell me where that.
Well, you still do that sometimes when you ask the question.
Yeah, I know, but throughout the years, I haven't been able to have sense of the board to accept that and to have some fortitude to be able to. You get somebody on soup opera and say, yeah, I agree with you, but then
You won't do it. They get scared.
Well, what's there to be afraid of? There's nothing to be afraid of. What are they going to do? By us not following what city attorney says, could they possibly do? They're going to come in and say, we're nullifying all of this. On whose authority did they nullify?
Well, basically, this task force could do anything they want.
Absolutely. I agree. I think it should.
It doesn't have that much juice to do it.
Well, no. We don't have the juice for enforcement.
Yeah, enforcement.
But nobody comes in here and oversees what we do anyway.
Yeah,
So
that's true.
we just do whatever we want. If you want to say that if 6 people show up and it's a quorum, then
If there's a majority vote of 6, then it passes. Okay, let somebody come and dispute that. Who's going to dispute it? Well, Mr. Creed's going to probably report it to the city attorney, and the city attorney will say, do that. Who's he going to say that to? He can't say the mayor doesn't have power over us, or the city attorney doesn't have power over us. So who's he going to say?
Yeah, we got voted by the people.
Right, so who's the authority that says you're going to have to take it to court?
I'd like
And
to.
we're gonna
Is it same
I'm
thing
all
with
for
other
it.
commissions too that are
You know, and
voted
let the chips
targeted?
fall where they may.
No, for us, it's specifically different. I was trying to find it in the ordinance.
See, that's what I'm trying to figure out. You know how today when you told me about not voted
But didn't have a chance. I taught a class right before this, and
I know, there's certain
it's been
things,
a
right.
really long
There
day.
are bodies that are called
Oh,
commissions.
yeah.
They hold a different status.
Yeah.
Okay, now.
Plus, my granddaughter's really sick. She's 3, and she has pneumonia. My son called this afternoon. He was just in a panic. Yeah, she apparently had a cold, and then over the weekend she was crying and saying her chest hurt. Now she's allergic to the medication they're giving her, and she has hives all over.
I remember when I was
Here, this is the key word. Present.
ever
A majority. Present showing up. Right? Question is, does a vacated
like his doctor said that I could go
let's putting that aside. If you have 8 members here, only 6 show up.
Right, yeah. Oh, no, yeah.
that 5-year-old within that
Right, right. I have a text from my son saying that she's a little bit better, and they also had she had a urine test and there was sugar and showed up, and the doctor was saying maybe she has diabetes. But that's she had another test and it was okay. Well, no, the doctor said actually when children in particular are under a lot of stress, they can, that can happen. No, I have diabetes, but for some reason, their sugar shows up in their urine. I'd never heard of it. And it really scared us.
Most of them apply, I think, what he says charter. There's some commissions that I'm still understanding how it would be chartered, because this is not chartered, this voter pass. I think most of the commissions that are yeah, I'm still understanding that voter pass thing. You know some commissions, right? Mm-hmm. That are not voter pass.
Mm-hmm. It'll be a long night.
They don't qualify.
We're on the 3rd item and it's in the 3rd hour.
Well, but maybe Mr. Garza had left.
Yeah, so did I.
He's scary.
I think most of the other commissions,
just wants to basically get something.
Like a park, those bigger commission. I think voter pass. It's not created by.
I've never looked at all of them.
We are back in session. Mr. Clerk, could you call item number 4, please?
Thank you, Commissioners.
Yes, Mr. Chair. Item number 4 is continued hearing on complaint filed by Charles Spitz against the local homeless coordinating board for allegedly failing to notice a meeting, denying access, and failing to allow for public comment.
Okay, this is a continued hearing. Jurisdiction has already been established. Mr. Pitts, please approach. Thank you for coming. You have 5 minutes.
This is primarily a meeting. This is just primarily a meeting that was not disclosed to the public. I received a flyer, and when I came to the meeting, I was kicked out, primarily just for showing up. I showed up. She told me I couldn't come. She jabbed me in the side, and I left. And I think the waters just gotten cloudy because it was a subcommittee meeting of the local homeless coordinating board. I just want to say hopefully the respondent will show up.
Okay, thank you. Is there anybody to present facts and evidence in support of the complainant?
Hello, it's unfortunately I again. I would think that good procedure, hope, civility, humanity would indicate that at this particular point, since the complainant has showed up and the respondent hasn't, that the respondent has waived all rights to any defense and that it's automatically decided in the complainant's favor. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody to present facts and evidence in support of the respondent? Matters with the task force. Member Johnson.
Through the chair, Mr. Reston, did you receive any information from the respondent on attending the meeting?
Through the chair, I informed besides my regular notification, I also added that the task force had instructed both parties to appear today. And that was conveyed to her. She did not respond.
Thank you.
She did not respond?
Through the chair, that's correct.
Thank you.
Thank you. Okay, at this time, since the respondent is not here, the complainant has 3 minutes to make any concluding remarks.
I guess my thing is that it just kind of just shows to her character that she just did not want to be accountable to the citizens of the city and county of San Francisco for her actions. This is kind of like the third Sunshine Ordinance Task Force meeting that she has not shown up for. The other one that she sent was the fourth meeting that she came to, that I remember she came, submitted a letter that she was going out on a social event and left before the item was being heard. So she just, I'm just wondering how long will she just flout the laws of the city and county of San Francisco and the state of California. So I'm just hoping somewhere along the line, I can just get her to act appropriately. I just don't think I don't know. I'm just got to figure out how far I need to escalate this so that either she gets removed from her job or she just starts complying with the laws of the city and county of San Francisco.
Thank you. The matter is back with the task force. Member Washburn, Member Kneber.
I'd like to make a motion that we find a violation of 67.21E for failure to appear or to send someone knowledgeable about the matter. I don't know if I'm not comfortable in going any further because on the merits of the case, we don't have basic information from Ms. Schlocketer that we would need to have, I believe, to determine whether or not this was a meeting for which public notice had to be given.
I would second that.
Member Knebber, Member Johnson.
Having been at the pre-trial conference, at the pre-hearing conference at the complaint committee, I know what Ms. Schlocketer had asserted there. I'm just dismayed that this is the third time she's not here to present it, because I don't think that we can take anything she said there and bring it here. I think that she needed to present that case here. And I would have to support, I don't know. I'd be willing to go farther, but I'm not there yet on motions.
Member Johnson, Member Wolf.
I have a point of order question. I know that we have 67.27 that we can find violation to fail to justify withholding, but in respondent's original email, she says that it's not a meeting of the local homeless board, so she's not going to appear. Is there some way to find a violation for failure to provide justification, or is it just caught up in the same ordinance section that Member Washburn just mentioned?
Member Snyder.
Well, I think I don't know the answer to the question whether 6727 applies to the meetings, because it's specific to the public records. But I understand what you're getting at, that she didn't explain. She did explain in the email, at least not, she did not before us, but in the email to Mr. Rustum, she said that the argument is that the meetings provisions of the Sunshine Ordinance don't apply because it wasn't the local homeless coordinating board.
But it could be a passive meeting body,
right?
And so she doesn't. She's taking it upon herself.
Sure.
So I'm just wondering if there's a. And then, in addition, just so that the discussion can go on, another point of order question is that I think this is a willful violation of not showing up, and I think it's pretty clear. Can we send it to the Ethics Commission instead?
Member Wolf.
I'll go backwards to Member Johnson's question. If you read in, I think it's 67, I was just reading it. Well, with regards to willful failure, that sending it to the Ethics Commission only applies to elected officials and department heads, not manager positions. And she's an analyst, according to her title. She's a board policy analyst. So you can find willful failure. You just can't send it to the Ethics Commission.
Thank you.
As far as the passive meeting, that would be a question that I would have, because on the original announcement on page 42, if you look at the bottom, it says representation by at least one person from your agency is emphasized mandatory, and that the s'il vous plaît, the RSVP, is to Ali Schlageter, who is the board policy and representative of the local homeless coordinating board. I would also ask who originally called the meeting, because the discussion of at least on this flyer, is not clear of who called it and why it is a question of why it was called, but who it's focusing on. What is McKinney's relationship to the local homeless coordinating board and or to the city? What is the jurisdiction and authority does this particular meeting have, since the representation is mandatory? What is going on at this meeting that requires such mandated attendance? And if this meeting is a requirement under some law, what is that law and why? And also, would this meeting be held independently if it wasn't called by the local homeless coordinating board? Or is it a requirement of the local homeless coordinating board to call these meetings? So those would be my questions had somebody had shown up, and I think lends to the gravity of the question that the complainant is bringing forward.
Okay, right now, I think it's relevant also that this meeting was held at 77 Otis Street, which is a city-owned and operated facility, or at least city-operated. Right now, there's a motion before us for just finding of one violation. So I think that's where the discussion should focus. Okay? Unless somebody wants to amend the motion, Member Johnson.
I would request to amend it to add a willful failure with 67.34.
Does the second accept?
Yeah, sorry.
Okay, Maker?
Yes.
Okay. So the motion now includes 67.21E and 67.34. Member Knebber.
I am not trying to make a case for Ms. Legater. I just in my recollection, first of all, she asserted that it was not a passive meeting body, it was just herself. But I don't have any evidence to back that up, so I'm not going to take her word, especially since she's not here. Secondly, just to clear up a couple things, the McKinney grant is for, I believe, for homeless youth. It's grants for homeless youth projects. So this was for any agency that has money through that grant project. Again, is that a passive meeting body? Are those people involved? Are they not? Whatever. That's a question that we can't have answered. So I'm willing to support the motion.
Okay. Is there public comment on this item? Excuse me, Mr. Garza, you already spoke to present facts and evidence in support of the complainant. Therefore, you are not allowed during the public comment session.
Thomas Piccarello again. Thank you. Couple things. Perhaps you need to have a discussion of presumptions when a respondent doesn't show up. You file a complaint in a court of law, and if the defendant doesn't answer, a default is taken. When Mr. Schneider can tell you, when you file a complaint and there's no answer, then everything in that complaint is presumed to be correct. So maybe that's one way you can get a respondent to show up. If the respondent does not show up, everything alleged by the complainant should be presumed correct. And then you'd have maybe better attendance by responding city agencies. Let me just speak factually about this matter, though. There's something I do know. First of all, the meeting was held at 77 Otis, which is where the local homeless coordinating board has their funding committees meetings every month. So the venue is a local homeless coordinating board venue. Secondly, if you look at the agenda, it's discussing what's called C of C public policy matters. That's continuum of care matters. That's with the language of the local homeless coordinating board. As pointed out by one of your task force members, RSVP is to Allison, who is the staff person of the local homeless coordinating board. Moreover, you see attention. All McKinney-funded programs that serve families, McKinney-funded programs are processed through the local homeless coordinating board. McKinney-funded is federal monies that are processed through the local homeless coordinating board. So, this is a local homeless coordinating board wanting to discuss matters about homeless families. This meeting, Mr. Pitts should have had access to this meeting so he could give input on any matters that was discussed at this meeting. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion by the task force. Roll call, please.
On the motion, Member Snyder?
Yeah, aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Wolf? Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. The motion passes. Mr. Clerk, would you call the next item, please?
Item number 5 is continued hearing on...
Excuse me for just 1 minute. This matter now goes to the Education Outreach and Training Committee.
Thank you, Mr. Chair.
I'm sorry for the interruption. Please
Item
continue.
number 5 is continued hearing on complaint filed by Deborah Benedict against the Mayor's Office of Economic and Workforce Development for allegedly failing to provide copies of a local contract.
Thank you, Ms. Benedict. Thank you for coming again. Thank you for your perseverance on this. You have 5 minutes.
My name is Deborah Benedict. I am a disabled person living in San Francisco and also the coordinator of...
Hold on, Mr. Chair, just a point of order before we begin. We're missing attorney advice on this item.
Through the chair, due to budget limitations, in discussion with the chair, I made the decision, and our office did in consultation with the chair, that if there's simple matters, we will not provide a memo. And this particular matter seemed relatively simple because the question really is whether the document existed.
Okay, thank you very much. Mr. Chair, I would appreciate if that were to be the case, that before we proceed, that be mentioned, because it was of some consternation to many of us at the last meeting that so many items did not have advice that we're usually regularly expecting.
Okay, thank you. Please proceed.
Yes, again, my name is...
Can you start the clock again for her, please?
Restart the clock, please.
My name is Deborah Benedict. I am a disabled woman living in Key West, and I am also the coordinator for Chapter 16, which is the San Francisco and Bay Area Californians for Disability Rights, which is the oldest disability rights organization in California. In relationship to this particular issue, there is a question I have about the way Mr. Rumstrom, no disrespect, put this on the board as a problem with the Mayor's Office of Economic and Workforce Development. And in fact, my complaint was against Martha Ann Cohen, personally, who is the special director. She's the director of special events who works in the Mayor's Office of Workforce and Economic Development. And I will mention that I have, after tremendous amounts of effort, finally gotten my phone records that I have with me, in addition to my cell phone, to show that that is, in fact, my number. After exhaustive efforts through the California Public Utilities Commission, to show you that I tried to contact Ms. Cohen personally. I showed up her office. The woman who is here supposedly representing the Mayor's Office of Workforce and Economic Development, who you've seen before, is a person who's I've only laid eyes on one time, and that was when I got Ms. Martha Ann Cohen's personal card. I had her telephone number because on November 1st, there was a presentation of the playoff game for the Giants in front of City Hall, which was extremely well attended, and which I brought in my cart a chair so that I could enjoy. Now, expecting that any event that was operated by the City of San Francisco in an outdoor public space would have an ADA area as required by law, I requested the ADA area from the people that were working at the site. And I kept asking individual after individual who was in charge, until finally, after the event, I was able to speak with Miss Martha Ann Cohen, who, when I said, "There's no ADA area," she said, "Sorry." So we do have a previous line that goes through to this particular complaint. And this complaint was based on the November 3rd event, which occurred in front of the City Hall in the same location for the celebration of the Giants, which, as you're probably aware, was extremely crowded. So after fighting my way through crowds to get to an officer to ask for the ADA area, I was first told that I'd have to walk all the way around through the crowds to the other side. And then, because there was an open area, I said, no, I'm disabled. I need to have access to the ADA area. Well, the officers conferred, and they called the person who was in charge of the production company that was running the event for the Giants. Now, I obviously was having a first interaction with this person, and they told me the ADA area is full. So, being an activist, I said, show me. That person made me leave my things with the officers at the area where I first was, which is obviously, which is not obviously, but was at Grove Street and Carlton Drive. And I had to walk through the areas that were blocked off, and we came to the disabled area, which had probably about 25 people in one area or less, and in the other area had probably about 25 or 30 people. And there were a few, maybe 5 or 6 wheelchairs in both sections, and the rest of the seats were vacant. So needless to say, as an activist, I not only counted the chairs that were there that were vacant, I counted the number of people that were there, and then I walked out and looked at where the ADA sign was and the entrance for 88, which was completely packed with people with no officers to allow any ADA person to come into this area. So needless to say, I was quite upset with the fact that the ADA was being given lip service and that ADA people were not being allowed into an ADA area at a public event, again, that was run through the city of San Francisco at some point. So my only contact was Martha Ann Cohen. And since I needed to ask her for information about who was responsible for writing the contract for the Giants to utilize this space, I asked her first, in letting her know that there is the Sunshine Ordinance Task Force, or the Brown Act said that I'm allowed to get public records from her. And the government code the government code says that that I'm supposed to get access. Okay, sorry. But anyway, the bottom line is I'm in an ADA complaint about this, and she refused to give me information until you guys took in the complaint. And it was an unsigned letter.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Okay. Seeing none, is the respondent present? Please approach. Thank you for coming, ma'am. You have 5 minutes.
Well, I'm here responding.
Could you identify yourself, please?
Maisha Hervey, Office of Mayor's Office of Economic and Workforce Development.
Okay.
I'm here. She asked for a copy, actually, of the contract for that event. So that contract actually doesn't exist. That contract is between the San Francisco Giants and Hartman Studios, and we don't have a copy of the contract. That was what her Sunshine request was, which we actually were late and delayed in responding to her. The request initially went to Martha Cohen, and Martha was not aware of the rules as far as responding and was out of the office after the event. When then Ms. Benedict went and filed a complaint that went to Martha Cohen on November 17th. She was still out of the office for other events because she does handle all the city and county major events. She then forwarded it to me on the 22nd of November. I responded to Ms. Benedict on the 23rd, indicating to her that we did not have a copy of the contract because it was between 2 private entities. And then we had received a second request for a contract with the San Francisco Giants that we didn't enter into contract for the San Francisco Giants for that event. Those are the complaints that I had received. No contract exists.
Okay.
Thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Wolf.
Yeah, ma'am, from the Mayor's Office of Economic Workforce Development.
Ms. Cohen. Oh, I'm sorry.
I'm sorry, your name again is?
Maisha Hervey.
Hervey, Ms. Hervey. My question is, you're saying that the city wasn't involved in this production at all, period?
No, the event was here at City Hall, but we, in fact, what she had asked for was a copy of the contract, which we did not have.
I just want you to answer my questions. I get that. I understand what you're saying. I have a particular line of questioning in order to either...
We did help coordinate.
Okay. Was this a Giants activity?
It was a Giants activity,
Okay.
correct.
And the production company is this group called Hartman.
That's correct.
And Hartman was in contract with the Giants.
That's correct.
Okay. Do the Giants have untetherable access, unlimited access to use city property whenever they feel like it?
No, but it was a major event, so it was coordinated with the mayor's office.
With the mayor's office?
That's correct.
Okay, so the mayor's office basically was responsible for the event?
We assisted with the event, yes.
That's not my question. You didn't answer the question.
We
were responsible for the event?
We were responsible for the event.
Who holds the insurance in case something goes wrong?
I assume we would have insurance, but I have not seen any of that paperwork.
Would you consider it akin to a supervisor approving a rally on the steps of City Hall for some other group?
I mean, there would have been.
I asked the question. Would you consider it akin to a supervisor approving use of the City Hall steps for some outside group?
Yes. I mean,
Okay.
there would have been permits, so it would have been a number of departments within the city.
So the supervisors are required to obtain a permit if they want to have like a rally outside on
No.
the steps?
No, the supervisors need to go through building management.
Okay, so they're just allowed by their own privilege of being an elected official to
there needs
make
a process.
arrangements. Right, but they don't need a permit.
No, not a permit.
Okay, so then any responsibility of what happens that day on the steps is the city's responsibility?
Yes, it would be.
Okay, so were the Giants, first of all, were you involved in any of this process
No, I
at all?
wasn't.
Do you have any details?
I do not. I am just here as far as responding for the public request. I don't have any details. I wasn't coordinating with the Giants.
Okay. Do you know if Martha Ann Cohen was directly involved in any of this?
I mean, she would have spoken with the San Francisco Giants, and she would have spoken probably with the police department.
Was she coordinating this?
She was coordinating with the San Francisco Giants, yes.
Okay. So now you may or may not know this, but do you know what the process is for informing a group like the Giants when they hold an event on what the requirements are?
No, I don't.
Okay. All right. That's all I have. Thank you.
Member Knebber and Member Snyder.
Thank you, Ms. Irving. I mean, I can understand where we're getting at with this, but I'm looking at this as a request for a document, and the document doesn't exist. So I'm having a hard time seeing past that idea.
I have a couple questions for Ms. Hervey that I think will speak to that issue. Did the city participate in the areas designated for people with disabilities, establishing those areas?
The city, I mean, I guess the city helped coordinate different areas, except that it was a public viewing. So the only areas that were blocked off were for the players and press. Everybody else was literally on the grass area in the Civic Center Plaza. There was no designated chairs. There was no areas other than the Giants family.
So there wasn't a plan for how to provide disability access in City Hall?
I don't know how that was coordinated, honestly. I wasn't in part of the process, so I'm not sure how any of the sections were set up.
Wouldn't there have had to have been some sort of
I'm sure
plan?
there would have been
And
a
the city
plan.
would have had to have been involved in that, correct?
Yes, but
So there's a way that Ms. Benedict could phrase her request. I think what she's looking for is documentation of the city's involvement in and participation in the disability areas. What kind of plan the city had?
I'm sure there was a plan, but what she specifically asked for was a copy of the
Yeah,
contract
no, I understand
that we
that.
don't have.
But so my question is, if she rephrased her request to get, maybe now that you understand better what it is she's looking for,
Mhm.
she could phrase her request in a way that might get her some documents.
I mean, she's basically, if she's asking where the designated sections were for disability. Is that correct? And that's her question?
Well, I don't know, but all I'm getting at is, perhaps Ms. Benedict, after this meeting, however we decide, can resubmit a request and get what she's looking for, and perhaps the city can help her get what she's looking for rather than just simply denying the request outright.
I mean, I'm sure we can. If we have what she's looking for, then we have no problem providing the documents.
Ms. Johnson?
That's no problem.
Member Johnson?
You can sit down, and I'm not going to ask a question. I, in response to Member Knebber, I do want to say that I know it may not be appropriate right at this moment, but the representative here seems to have a lot of answers to where that information is, so I would consider that a violation of 6721C, of assisting the requester with finding of saying where that information is, because she clearly knows. She knows what. I mean, this person clearly knows what the. In addition to the timeliness of the response, it's I understand that the public sometimes doesn't know who to send it to, and if someone is normally and constantly out of the office, perhaps they could have a reply email or something to let people know not only what other department they could go to, but what other person within the department is designated to answer sunshine questions, which is required under the ordinance. So definitely, I feel that they have represented that they have the information, that they could have assisted her where to go, or at least in some direction.
Member Knebber?
I agree with you. The only problem I have with that is they weren't. We can't be sure that they were sure that she was looking for ADA information in that. I mean, if she only requested the contract, which they don't have, I mean, that's making an assumption. So I'm not saying I disagree with you. I think that that's just something that we need to think about.
Member Snyder?
Yeah, I do think 6721C imposes an affirmative obligation on the city to provide some assistance. I think it's unclear on the facts we know right now whether, well, let me just say, if you had a situation where a requester affirmatively rejected contact from the city said, well, can we ask you what it is you want? And the requester said, forget about it, I'm not talking to you anymore. Well, then I think the city's obligation to assist would evaporate. However, if she was open to some assistance and the city just did nothing but respond with 2 sentences saying there is no such contract, go away, I think they did not fulfill their affirmative obligation under 6721C. So if I could ask Ms. Benedict a couple of questions? Are you still around? There, you're behind the podium. Did the city, so before us we have, I think, 2 letters. One moment, please. Sorry, let me just get them in front of me. Thank you. Yeah. So we have two letters, one on November 23rd and one on November 29th, saying, in essence, we apologize for the delay. A colleague was out of the office. There is no such contract. The city is not involved in a contract because there wasn't. It's not a party. We don't have a copy. Did the city? Were there other efforts by the city other than these 2 letters to contact you?
No, I showed up at the office and asked for Miss Martha Ann Cohen. I had already, as I stated, spoken with her directly about ADA issues. So she was aware that there was a continuity in my contact for the event that occurred 2 days later, and that the reason that I was asking for that information, now I'm not putting anything in her mind, but when you have a direct contact with a person and you say to them, I came here and looked for ADA accommodation and you don't have anyone and they look at you and they go, sorry.
So this contact, this in-person contact, was this before you submitted your request for the contract?
Absolutely.
Okay.
I started calling on the 2nd to find out about the procedure, and I left messages, 2 messages, which I have now records to show that I called on 2 different occasions to Martha Ann Cohen specifically, because she was identified by by employees of the city as the person that was in charge of the event on November 1st. So understanding that she was in charge of the playoff information, my natural thinking was that who is going to be in charge of special events but the director of special events at the Mayor's Office of Workforce Development. So the bottom line is it came down to I'm trying to get information very specific to ADA accommodation, and when I had problems with the organization that was running the event for the Giants, I wanted to find out what the procedural mechanism for engaging an organization like the Giants, and specifically in this instance, the Giants, how does the city engage with an organization of that type in using public lands, and how is that mechanism? Who do they talk to? What are the procedures? And I didn't know how to ask for that except by asking for a contract, because as a former realtor, I can tell you that nothing is good without paper. So somewhere there's paper, and from my experience, paper is a contract, which means that a person agrees to do something, they show evidence that they're capable of providing what is required, and in this case, ADA accommodation was definitely required because they did have a section. It's just that they decided that they weren't going to actually allow people that are disabled in.
Okay, well, let me
so
stop you for just a moment.
Yes.
I'm just trying to put together a timeline of contacts. And so you had this in-person contact.
The second.
And then you sent in your formal request.
Yes, no. Then I went into the office itself because obviously 2 calls did not provide any information. And what happened...
after you sent in your letters, did the city contact you at all?
No.
After that, other than... I'm sorry. After you put in your request, did the city contact you at all?
Absolutely
other
not.
than these 2 letters?
No, they only contacted me after I came and put in a violation of Sunshine Law by refusing to help me. You know, honestly, according to overview of public records and public meeting law, it says the department heads, city personnel are supposed to provide access to the public of city records and information. In fact, if I don't phrase it exactly right, they're supposed to assist me in getting to the direction that I'm supposed to get the information. But with no contact whatsoever, and in fact, since these are addressed directly to Martha Ann Cohen, and I get letters back, quite frankly, that are unsigned, which to me is a very subtle screw you, I really understand clearly that there is no real interest in continuing forward. And in fact, the fact that this lady who I only saw one time who handed me Martha Ann Cohen's card is here is to me evidence of the fact that there is really no interest in helping me get this information. And
I would say there's nothing stopping you from submitting a further request.
I don't know how to phrase it other than a contract.
I'd just say you could phrase a request that's much more broadly worded to say documents relating to or correspondence relating to. I mean, there are a number of ways you could phrase it that would capture things other than contracts.
I see. And in fact, obviously, in addition to going to her office, I went to the Office of Contract right on this floor and asked them specifically for contracts related to the Giants, and they didn't have anything. So I didn't know where else to go but here, honestly.
All right. Well, thank you for your...
Member Johnson.
I would like to... in addition to the 21C about assisting the requester, I would like to point out that, Ms. Benedict's original request says, this is a request for access to examine the contract between your offices and the San Francisco Giants for November 3rd, 2010, the date that they had the parade and event on the steps of City Hall. Now, I don't think that that necessarily implies the contract for the actual event. She's asking for information about between your offices and the Giants. Now, just because the department responded and made the assumption that it was about the contract for the event, if I worked in the city, me personally, I would assume that that was the contract that the city had with the event. Just because she worded it that it was with the Giants, I think that that should have triggered something to the city departments, that she was looking for something that she wasn't quite necessarily sure. You know, just because they made the assumption that it was for the production, I mean, that the production company is the company that sets up all of the events, but she's clearly asking, because it was focusing on the Giants, how would you know that there were, unless you were involved in the entertainment business, or like Member Wolf and I, having seen people go through the process of getting permits to stand on City Hall or being told your speakers are too loud. You have to go through that process. But I still think that that should trigger something within the city, that she was looking for some kind of a contract between the city and what happened that day during those events. And there's clearly, I mean, permits are contracts. Contracts are not just a specific contract that, you know, the literal definition of a contract. We have oral contracts. We have all kinds of things that constitute a contract. And I think that the argument can be made that the city is responsible under the Sunshine Ordinance for furthering, finding out, asking questions. And the fact that they didn't respond to her until way past the 10 days, you know, is to me indicates they made no effort. They just construed it one way.
Member Knebber?
I agree with you on the delinquency of the reply, but I can argue that they did respond and they said we have no. The contract. Their response was directing her, saying there is no contract between us. That contract is between Hartnell and San Francisco Giants. I would argue that that is saying, if you want information about it, that is a place where you can go get information about it. I mean, legally, I think that they fulfilled that part. Now, the delinquency is another part, and I'm upset about that, but I can argue that that is a response, and that is directing them where to go.
Member Johnson.
Is that because you're saying that there is no contract between the city and the Giants, even though Member Wolf questioned her and asked whether the Giants could just willy-nilly make a contract with a production company? Because there is indeed a contract between the city and the Giants for that day. Or it could be Hartman Studios.
See, that's
but
the
there
thing.
is indeed.
I'm saying that could be the case there. I mean,
So you were saying that she would have had to, that the public would have to know to ask for the contract between Hartman?
She can go to Hartman or San Francisco Giants to try to get that. And if they have a contract with the city for a certain amount, then
But my question to you is, why do you say if, when you know they have to have a permit, and a permit is a contract? If they break something in the permit, you can bet you that the city is going to say this is a contract and you didn't fulfill your part of it.
Member Wolf?
So, first of all, let's look at, on page 50, Ms. Benedict's original request. She asked in the last sentence of the first paragraph, she says, requesting an appointment to view the contract documents. Not a contract, but contract documents. She may not know what an MOU might be or whether there was some special kind of paper that the Giants have to sign, you know, indemnifying the city or what have you. But she's asking for any kind of relationship, documents with regards to the relationship pertaining to the Giants celebration on that day and the employment to that production company, because she has no idea who's connected with who. So if we go to 67.21, we can start with B. Okay, first of all, the date of her request was November 5th. The first date of response from the mayor's office was November 23rd. That's in violation of Section 6721B. Okay, it wasn't within 10 days. So that's the first thing. The second thing would be, as Member Johnson pointed out in paragraph C, a custodian of public records shall assist a requester in identifying the existence, the form, and nature of any record or information, so on and so on. I see, and that shall do so in writing within 7 days following a receipt of a request. Well, that didn't happen. In D, if the custodian refuses, fails to comply, or incompletely complies with the request described in B, the person making the request may petition the supervisor of records for a determination whether the record requested is public. Well, she didn't get that answer either. In F, we skip E, we go to F. The administrative remedy provided under this article shall in no way limit the availability of other administrative remedies provided to any person with respect to any officer or employee of any agency, executive office, department, or board. Nor shall the administrative remedy provided by the section anyway limit the availability of judicial remedies. But she wasn't even provided an opportunity of where should I go next. And then in G, maybe not G. Well, in G, it just says, in any court proceeding pursuant to this article, there should be a presumption that the record sought is public, and the burden shall be upon the custodian to prove with specificity the exemption which it applies. So if they're saying that there isn't a contract, then they have to prove with specificity the exemption. But that it's kind of weirdly worded there, but because it says in any court proceeding pursuant to this article, but still the spirit of Sunshine, I think, applies there. So I will wait if there wants to be more discussion to make a motion. If there's no more discussion, then I will make a motion on those five items.
Member Snyder?
Yeah, the only question I would raise about that is that 6721D, I'm not sure that applies. I'm not sure did she petition the supervisor of records for a determination whether the record is public? I'm just not sure that fits. I mean, I see D as a if you don't get a response initially, then you go to the supervisor of public records and say, can you tell me whether this is public? Is that what? Well, I mean, I think that's a step that she just didn't take. I don't think it matters that much to.
Okay.
I would just.
That's okay. If you don't mind, I just have one question for Ms. Hervey. In the letters on page 52 and 53. They're unsigned. Who are they from? Who sent them?
I sent them.
Okay. And you sent them on behalf of?
Of the office. On behalf of Martha Cohen, on behalf of the office.
On behalf of the office.
Yes.
Okay, great. Thank you.
Okay, at this time, the respondent and then the complainant will each have 3 minutes to provide any concluding or rebutting remarks. Ms. Hervey?
As far as the delay in response, unfortunately there was a miscommunication in our office with Martha Cohen, not aware of the time frame. As soon as it's sent to me, I did respond. As far as just reading it, asking for a contract, had it been worded differently or said anything else, we would have provided, or I would have pointed her in the appropriate direction to get some answers. But in fact, that's not what was asked. Asked for a contract between Giants and Hartman Studios, which we did not have a copy of, so that was why the response was short and straight to the point, because we did not have a copy of that. If it was worded differently, I would have been happy to point her in a good direction as far as anything else that she needed, and I mean, that's pretty much it. We just responded to what she asked for.
Thank you. Ms. Benedict?
Hi. I don't know who I would have asked for more information since both letters were unsigned. I had no idea who was sending them. I knew who I was sending my letters to, but there was no clue as to who was answering those letters, whether it was Martha Ann Cohen, who I addressed my letters to, or who knows who in the office. So, quite frankly, I don't think there was really any remedy. Plus, I don't really know what the next step to ask for because I'm not an expert on either sunshine law or the procedures necessary to move forward to get the information that I'm looking for. I didn't have any doubt whatsoever that the Hartman organization was hired specifically by the Giants. They were only named because of the fact that it was a production company that they hired, but obviously it was the Giants who I was interested in getting the information about, because whether or not they hired Joe Schmo down the street, the fact of the matter was they did not comply with ADA rules, and certainly not in spirit or in fact. So my lack of knowledge of how to ask for information, or the record, I think it was D, that was something about, the keeper of the records. Well, if Martha Ann Cohen, the director of special events, isn't the keeper of record, I don't know what that phrase means. I have no clue that if there's a person with that job title in the city of San Francisco. I went to the only logical place that I could go based on the fact that this is the person who has the job title that says that they are in charge of special events. And if the Giants weren't a special event, I don't know what was. So my asking for information was specifically about the Giants, and trying to get information from that office was only activated after my complaint. I don't honestly believe I would have ever heard from anyone in that office had I not complained to you directly. So that's all I have to say. Thank you.
Thank you. Matter is back with the task force. Member Johnson.
Just two things that just in support of saying that asking for a contract between your office and the Giants. A lot of things in the city aren't very logical. Even the fact that she had to go to the mayor's office of economic and workforce development. I mean, how would you know? I wouldn't even know that that's where you go for special events. And this triggered a number of contracts within the city. Even the MTA would then be forced to work on closing the streets, and the police would bill them. So there were a number of contracts. And the city employees know that because I know it, and I'm just marginally involved. And then secondly, I encourage Ms. Benedict, you to speak with Supervisor Mark Farrell's aide, Catherine Stephanie. Do you know her? She was an aide for the former supervisor in District 2, McKella. Her name is Catherine Stephanie. She's an aide for District 2 Supervisor Mark Farrell. And she was the aide for Supervisor McKella Alioto Pier, who, as you know, was a big advocate for ADA. So I encourage you to speak with her, for whatever information she might be able to help you with. That's it.
Member Wolf.
Yeah, I would. If I can just ask Ms. Hervey one more question, I think that is important to ask that on this. Do you know of any documents of engagement between the mayor's office and the Giants for this event?
I don't.
Who would?
Martha Cohen may.
Okay.
But from what I'm aware of and what she's told me, there are no physical documents.
Okay, thank you. I would also add to Member Johnson's suggestion the mayor's office on disability. They are very proactive on items like this.
Is there a motion?
Public.
Is there a motion?
Okay, so I'll move to find a violation of Section 6721B, C, F, and G. I'm sorry, not G. B, C, and F.
Is there a second?
A second?
Okay.
Oh, can we make a friendly amendment, or does someone else do that? Can I make a friendly amendment to 67.25, the immediacy of response?
I'm open to that, sure. So 67.25, what was it, E? 25 what?
A?
25A?
Yeah.
Yeah, go ahead.
Just one comment. I don't know that 6721F applies because all it does is provide that the remedies available under the Sunshine Ordinance don't limit other remedies. I don't know that there's a way to violate 6721F.
Mr. Chair,
Member Wolf.
if I can respond to that. It says the administrative remedy provided in this article shall no way limit the availability of other administrative remedies to any person. The administrative remedy has to be applied, okay? And the administrative remedy that she was seeking was through the mayor's office. The mayor's office didn't provide her with any additional remedies. So, you know, I see that as, because inclusive of this, of 6721, starting with A and then B, which are people that are supposed to be providing help with the requester, they didn't provide her with any additional administrative remedy. So as far as I'm concerned, it was prohibitive.
Member Snyder?
I think, and maybe DCA 3 can correct me if he knows otherwise, but I think that by administrative remedy, what the ordinance is referring to is this process that we're going through right now. The remedy being this administrative body finding a violation. Is that, Mr. Threet, do you have anything to add to that? Am I reading that incorrectly?
Mr. Threet?
Through the chair, Member Snyder, I believe that you're explaining it correctly.
Thank you.
The administrative remedy is us finding a violation. And all F is saying is that any remedy that we provide here doesn't limit her.
Okay.
Okay.
I follow you there. Okay, so I'll strike F. So we have 25A, 21B, 21C.
Member Knepper?
I would like to propose an amendment to separate 6721B from the other motion.
Without objection?
No, I object.
Okay.
Okay. We have two objections to separation. Do you want to make a formal motion to separate?
I would like to make a formal motion to separate.
Is there a second? The chair will second. Discussion. Okay.
Mr. Chair, I don't see the need to separate it. It's all part of the same paragraph, and one applies. C applies if B doesn't happen. I just think that they both are complicit with each other in this particular case.
Member Knepper, just to clarify, the one you want separated out is 67.21B or C?
B.
B, okay. Further discussion? Roll call, please, on the separation.
On the motion, Member Snyder?
No.
Snyder, no. Member Manny?
No.
Manny, no. Member Washburn?
No.
Washburn, no. Member Knepper?
Aye.
Knepper, aye. Member Wolf? Wolf, no. Member Chan? No. Chan, no. Member Johnson?
No.
Johnson, no. Member Nee?
No.
Mr. Chair, we have 1 aye and 7 noes.
Okay. That takes us to for any further discussion on the motion. Is there public comment on this item?
Thank you. I respectfully withheld my comment during the complainant's part because I knew I'd be thwarted at commenting now after I've heard all the full facts. First of all, it amazes me that the city, which has to sign a piece of paper saying that they understand what sunshine is and how it's ruled and enforced and everything else, didn't respond within the time. So I think that needs to be investigated as to how the mayor's office didn't know what sunshine was and had to respond within 10 days. I mean, I find that beyond bizarre. Secondly, this part about a contract, and it's not there, and that's what they asked for in this particular piece of paper, and a rose being a rose by any other name. We had the same thing with the administrative hearing. that he was using, and when the city attorney disagreed, everybody just bowed over because of his definition of what administrative relief was. Well, it can be argued either way. You don't have to necessarily respect his opinion. Now, the point about whether there was a contract or not, and whether, you know, this contract, it's written or something like that, I can tell you from personal experience that to say that there's something that's not there, we don't have it, doesn't necessarily mean that it's not supposed to be there, or that they don't have it because of my particular case, which happened 10 years ago with the medical screening, in which this city got up and said there's no medical screening, even though it was required by law, but you guys ruled, well, there's not there, so they can't produce something they don't have. That's another thing you need to consider. Lastly, the last thing I'd like to tell you that you need to consider is the fact that just because there might not have been a written contract doesn't mean there's not a verbal contract. So how would somebody get the record for a verbal contract? It's an interesting question. I just thought I'd ask it.
Thank you. Is there further public comment?
Thomas Piccarello again. Excuse me. First, I want to thank the representative from the Mayor's Office of Economic Workforce Development for showing up. Thank you. And then let me say I'm encouraged by the discussion on this matter by the task force. Clearly, you know, she asked for a contract and one did not exist. So you could have easily just slam dunked her. But Task Force Member Johnson recognizes the spirit and the intent of the Sunshine Ordinance, which is, you know, to help the public get the documents that they need. So I want to thank the task force for not just reading the letter of the request by the complainant, but recognizing the spirit of the Sunshine Ordinance. Thank you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Further discussion. Member Wolf.
I would just like to say in closing for this particular item that, you know, had I thought about it sooner, I would have added paragraph E2, because one of the questions I did fail to ask was, what's the regular practice for such a thing? Are documents usually drawn up for such events and relationships? And if so, the task force can then determine whether that's public. And if it is then public, we can, by Section E, we can order, actually the task force can order the custodian to produce the document. And if they refuse to do that within 5 days, then the task force can notify the district attorney or the attorney general. So I'm just saying in the future we should also remember that Section 6721E has a lot of juice in it, and we should avail ourselves of it in the future.
Further discussion. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber, no. Member Wolf? Aye. Wolf, aye. Member Chan? Aye. Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chan, we have 7 ayes and 1 noes.
Okay, this matter is referred to the Compliance and Amendments Committee. Mr. Clerk, could you call the next item, please?
The next item is determination of jurisdiction on complaint filed by Deborah Benedict against the San Francisco Bar Association for allegedly not meeting Chapter 12L requirements.
Okay, is there a motion to accept
move we find jurisdiction?
Second.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Aye. Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. That takes us to substance. Ms. Benedict, please approach again. And again, you have 5 minutes.
I look at, on a pretty regular basis, the nonprofit book that is both in the library and also at the clerk of the supervisors, so that I can make sure that I'm absolutely certain that a meeting is listed or not listed. And I was in particular interested in attending this meeting because I had gone to the Volunteer Legal Services Program presentation at the Hastings Law School and gotten information that was actually incorrect. So I wanted to speak directly to the board of the Volunteer Legal Services Program about the information and about the fact that because they were using English only and not showing letters, that people who did not have English as a primary language left or sat there as their numbers were called because they didn't understand the English word for their turn. So I wanted to tell them about that as well. So in trying to go to that, I went to the book in City Hall and I looked at the date that they had listed, and I got ready and I went down to, I think it's Morrison and Foster was the advertised location, which the guards call MoFo. So I was on the floor at the time, and the individuals that were the receptionists said, it's not happening, it's not here. So from their offices, I called the clerk's office, and I had the clerk go into the book and look and confirm the fact that there was an advertised meeting for that date and no cancellation on that particular date. So I was in the right place at the right time. It's just that they hadn't bothered to notice anyone about the fact that there was not going to be a meeting on that date. So I considered that. I'm not, obviously not an expert on sunshine law, but if you're advertising a meeting that's supposed to be a compliance meeting and you're not having it, that was a problem, because I wasn't happy to show up and have nothing going on. And that's basically what happened.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you for coming. You have 5 minutes.
Good evening. I'm Mari McKeever with the Volunteer Legal Services Program of the Bar Association of San Francisco. And as we've indicated in our response, it's our position that we are in compliance with Section 12L.4 of the Administrative Code. We have supplied you with copies of faxes in which let me just walk you through the facts real quickly. We provided notices as required under the section on October 14th, notifying the public of a public board meeting scheduled for November 19th. We were then notified by some board members that they could not make that meeting, despite our efforts being the staff to confirm with them that they were available on that date. We then rescheduled the meeting for November 22nd and sent the necessary notices to the public library as well as the clerk's office on October 18th. I have verification of receipt of all of those notices with me. I provided some of them in the response, and I have some additional verifications that I can provide to you tonight. And I would also like to note that on the fax cover sheet for the October 18th notice, where it was notifying the public that the meeting had been rescheduled to November 19th, on the cover sheet it indicates that the prior meeting had been canceled.
Thank you.
Sure, thank you.
Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Okay, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. The respondent, do you have any concluding or rebutting remarks?
That's respondent.
Am I the respondent?
No, you're the complainant.
Okay.
Do you have any concluding or rebutting remarks you wish to make?
No, I just welcome any questions.
Okay, thank you. Ms. Benedict?
I can only tell you that when I was going through the book, I don't know the date that they sent in the other information, but I had the information written down, and when I called the clerk's office, I asked them to read the document directly from the folder to me, and they read that document, said that it was supposed to be a meeting held, and obviously, if there was information, you'd think that it would be collated or together, and they might be able to see that the next page or the page before would be canceling the meeting. But that information didn't come to me as I was standing in the office. The person that I spoke to, who unfortunately I did not write their name down, but I called directly from the office to the clerk's office and spoke with the person in that office, and they confirmed to me that that was the location and that was the time of the meeting.
Thank you. Matter is back with the task force. I have some observations here. This may be kind of an unfortunate mistake on the part of whoever answered the phone when Ms. Benedict called. It was Ms. Benedict. It was the clerk's office you called, the clerk of the board.
Yes, sir, and
Okay.
it was a female person that I
Okay.
spoke with.
I think it was unfortunate that whoever answered the phone missed something somewhere. We have some documentation here indicating that timely notice of both the originally scheduled meeting and the scheduled change were faxed to both the public library and the clerk of the board's office in plenty of time. We have a transmission notice on October 18, faxed to the library on the schedule change. We also have a fax notice on that is stamped as received at the Board of Supervisors, October 18, showing the change. So I don't see here a violation on the part of the Bar Association. Again, it's regrettable that there must have been some kind of snafu at the clerk's office, but I don't see the Bar Association at fault here. Member Snyder?
Yeah, I agree. Heading into the meeting tonight, there was no evidence in the packet of anything being sent to the Board of Supervisors, at least not that I saw. But when we got here, sure enough, on the table here was a stamped copy of the notice as sent to the Board of Supervisors. So like Chair Nee said, it's unfortunate that the information Ms. Benedict got was wrong, but that erroneousness can't be, I don't think, held, that the Bar Association can't be accountable for that erroneousness because according to all the evidence we have, they provided sufficient notices and at the right time.
Further comment? Okay. Is there a motion? Is there public comment on this item?
Yeah, I mean, I understand the substance of where you're leading in terms of your determination here, but I'm a little troubled by the fact that I'm sure this woman's a lawyer. She's presented you documents just now, and somewhere in the back of my mind, there's something on your Sunshine Ordinance saying that she's got to show good cause why she didn't submit these 5 days before the hearing. So in terms of process, you shouldn't allow these documents to go in front of you without her explaining to you why they weren't submitted timely. And at least give the complainant an opportunity to review the documents. She probably doesn't even, I don't know if she was handed the documents that was presented by the lawyer for the Bar Association. So I got a problem with the process here. You should not allow a respondent to submit documents at the time of the hearing. Yeah, your sunshine ordinance doesn't allow you to do that. I think it's 5 days, unless there's a good explanation as to why it couldn't have been submitted at that time. Thank you.
Further public comment?
Unfortunately, once again, having been through this illustrious process of illusion, the prior gentleman was correct. My cases, nobody ever seems to, respond within 5 days, and then it's continued, and then the other side gets to come in and then present their evidence when it wasn't timely in the first place. And the person, like me, who complains, isn't, adjudicated within the 45-day time limit. Then he's also further hindered by a bad policy and false procedure of 11 seats, which 3 are not seated at, that vote against him automatically in addition. And, the quorum issue. So, once again, I have to continually state that what are you guys here for? Because obviously you're certainly not here for us, which is what you're mandated for.
Is there further public comment? Seeing none, public comment is closed. Member Wolf, Member Johnson.
I'd just like to notate that on pages 66, 67, 68, and 69 are the same documents that they had distributed. The only difference being was the clerk's stamp of when they received it, which was on the same day. So these are, they just, what they presented was just the documents that they had sent over, not the documents that the city had received. So they normally would not get that. They send it, the city receives it, the clerk's office stamps it, and then puts it in the book. Same thing with the library. So I think if the issue, I think more of the issue is in which book did it not appear, and it's that office that was deficient in not making the proper posting. I'd also like to notate that for both these meetings that the send date or the posting date is at least 3 days prior to the meeting, which is within compliance to the Brown Act.
Further discussion? Is there a motion? Member Washburn.
I may be missing something, but the various fax transmittal pages are all to the main library and not to the Board of Supervisors. And I noticed that when I was reviewing the
Mr. Rustum, can you tell us what is the fax number for the clerk of the board's office?
Mr. Chair, it is 415-554-5163.
Thank you.
Excuse me, Mr. Chair, just a point of order. The requirement for posting of agendas, is it specifically only at the library as the official location, or does it have to be both the Board of Supervisors, clerk's office, and the library?
I believe it has to be both.
Okay. Shall post. Okay. All right, then.
What Mr. Snyder said.
Then I would suggest, then again, if it was not posted at the clerk's office, then the issue is not with, the question, okay.
See, they sent it from the clerk's office. That's what this says.
Oh, okay. Okay, I see. That's their further evidence. Okay. Gotcha.
What, Member Washburn, I think you're right. I think what we have in the packet shows only that they sent notices to the library.
Yeah, right.
They,
no, I know. I have that
okay.
too. I
Gotcha.
believe that they did send them to the. Yeah, there's no issue
Gotcha.
there.
I missed that. So what should we do here?
Is there a motion? Seeing none, this matter is concluded. Both sides are thanked for your attendance tonight. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair, the item number 8 is determination of jurisdiction and complaint filed by Dorian Maxwell against the San Francisco Municipal Transportation Agency for allegedly not providing documents related to a union contract.
Is there a motion?
I move we find jurisdiction.
Is there a second? Moved and seconded. Could you speak into the microphone, please?
Second the motion.
Okay. Moved and seconded. Discussion. Is there any public comment on the jurisdiction question of this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Yeah, Mr. Chair, we have 8 ayes.
Okay, that takes us to substance. Mr. Maxwell, please approach. I would ask that the complainants and respondents both take seats in the front row. It'll save us a few seconds here and there, but it's getting late, and that'll make it easier for all of us. Mr. Maxwell, thank you again, sir. You have 5 minutes.
Basically, around November 9th, I don't have the actual paperwork in front of me. I grabbed the wrong binder. I wrote a letter request to the Human Resources Department requesting copies of all the addendums and side letters to our MOU that between the SFMTA and the 9163 transit operators in our local transport workers union, local 250A. I also tried to get by petition for the executive board of our union to give me copies of the letters, and after we got all the petitions and things together, they told us that they didn't have the side letters and we would have to go to the Human Resources Department to get them. Basically, we're under contract, and any changes to the contract that I'm covered under, I should be entitled to any information about any addendums or any side letters pertaining to things that I must know within our contract. And once again, I didn't get any response from the MTA in respects to requesting the side letters. That shows that they don't have any respect for an employee if he wants to get information about his or her MOU. It's sad that we have to work with an outfit that disrespects total just for basic information that I should be entitled to because I'm affected by this MOU. I should be entitled to receive the information that I requested or a response or why I can't get the information. That's total disrespect. I'm trying to get information and no one's responding to me. It's like I must be talking to a wall or something. And it's sad that I have to work under this total disrespectful environment. I mean, it's just sad.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you again. You have 5 minutes.
Rumi Ueno, Employee and Labor Relations Manager. I spoke to Mr. Maxwell after I understood that it was more than viewing his personnel file that he was seeking. So I spoke to him to ask him specifically what his concern was. And my understanding is that Mr. Maxwell objected to a postponement of a hearing and thought that perhaps there was a side letter associated with a postponement. I spoke to him and explained that there was no side letter covering that. There were waivers of time limits, and that is contained in the labor agreement between the 9163 transit operators and the SFMTA. So I asked if he was speaking about that. Part of the difficulty is, to my understanding, both parties agree to the postponement of the hearing. He is represented by TWU Local 250A, and when his union representative agreed to the postponement, that's basically what we honored. So we're prevented or precluded from dealing with him directly because he is represented. Our assumption was when the union agreed to the postponement, we would go forward on the new date. There is no side letter covering what he is looking for, so we can't produce something that doesn't exist. His objection about the postponement, we can deal with through his union. I wasn't aware that he objected to it, but his union agreed to it until I spoke to him.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Mr. Threed?
Through the chair to the members, I just wanted to note that I became aware after drafting the memorandum that there was an additional provision that I neglected to include in it, and it's 67.24C5 of the Sunshine Ordinance, which provides that memorandum of understanding between the city and employee unions are not exempt from disclosure.
Thank you. Member Knebber, Member Wolf.
Again, this is another issue where, I mean, the request is for all memorandum, not specifically dealing with side or whatever is going on. It's a request for all memorandum and addenda, or excuse me, all addendum to the current memorandum of understanding. I think it's producible. It's information regarding to a contract. He didn't specifically say that stuff that had to do with postponements or whatever. It's just all addendum to the memorandum of understanding.
Member Wolf.
Yes, Ms. Uno. It seems that Mr. Maxwell had sent you a letter on September 9th. Did you respond to that letter?
No, I didn't recall getting it. I'm sorry.
He then subsequently, 2 months later, sent almost the same exact letter, dated November 8th. Did you respond to that letter?
No, I don't recall getting it.
Okay, thank you.
Further discussion from the task force? All right, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks.
I believe Mr. Maxwell's request is based on his understanding that there are a number of side letters that existed, and I believe a number of side letters did exist in the past, but a number have been invalidated or replaced. So we don't have side letters to provide to him. That's why I had a face-to-face discussion to find out what it was he was seeking, and that's when I discovered that he had an objection to the postponement. And that's not covered by a side letter. There is no side letter. We don't have any side letters to provide to him. We do have a labor agreement, which I believe he already has. That covers the...
Thank you. Mr. Maxwell?
The request was for side letters of an agreement, an addendum that was done to the current MOU. If I'm affected by the current MOU, I'm entitled to know what side letters have been issued in respects to the MOU. Other agencies, once they make an agreement, they hand a little memorandum of understanding change to the employees. I don't understand what makes the MTA so special that they're above everyone else and don't have to do what everyone else does. I mean, it's the law. The law is the law. If I'm covered under the MOU, I'm entitled to whatever changes that comes through that affects me. like they changed the absenteeism policy. I don't have any. I mean, I don't even have any letter of agreement on that. It's a whole bunch of things that they change that we don't have information about. If we're entitled to side letters of agreement, in addition to what's been changed in the MOU, even work rules or disciplinary procedures or time waiving periods, I'm just going by what I have here. If there's any changes in that book that I have, I should be entitled to the changes so I can add it on to what I already have. I'm entitled to know what I'm up against, or whatever disciplinary action or whatever that I need to know about that's in the covered under the MOU. I might have to refer to it for something later on down the line. And if it has been changed and I'm submitting information in respects to what's in the MOU and it's been changed, then whatever I'm disputing or whatever I'm talking about is going to get tossed out because I'm submitting information that's not factual or has been changed. So I do feel that I do have a right to know under what changes have been implemented under the MOU or whatever agreements that's been made. I should be entitled to it if I'm covered under it. Thank you.
Thank you. The matter's back with the task force. Member Johnson.
Mr. Maxwell, I just have a couple questions. How long... Ms. Uno said that she spoke to you to ask you to get a little bit more information about what you were looking for. How long was that after you sent out the request?
She approached me last week when we were here last week at the previous meeting. She approached me then with that.
And
that's been about December, so it's been about 2 months now. I mean, it's totally...
Did you receive any response at all before that? Okay, then my other question is, when you talked to her, did you agree that you wanted only the side letters associated with waivers or objecting to your hearing?
I just mentioned it. I just mentioned that particular one.
Okay.
But
thank you.
I wanted them all.
Okay, thank you. And then, Ms. Uno, I have one question for you. Could you give me an idea of the volume of documents the side letters are? Are we talking hundreds of pages?
No, I think there's some misunderstanding that Mr. Maxwell has. I believe he might be referring to negotiations that the city held, but this particular union rejected the tentative agreement, so there is no replacement labor agreement.
But you did mention that there are side letters in replacement?
There were side letters in the past that were invalidated. There may have been some side letters in the past.
I'm talking about the totality of side letters, not just his issue.
I understand that. What I'm saying is many of those old side letters were invalidated because there is a provision in the labor agreement that requires that it go before the board.
So are you telling me now that there are no side letters at all?
No, and that's why I had a discussion with him to say, what is it that troubles you, and perhaps I could address it. And my understanding was he was trying to get to the issue of objecting to a postponement that occurred. And so
I just want to make sure. I just wanted to know if there were side letters. If he asked you for copies of side letters of the agreement and the addendum to the current memorandum of understanding, if that doesn't exist at all, not related to just his subject, and how many pages that would be. I wanted to get an idea of the volume of what that would encompass.
0 pages.
Okay.
There aren't any. And he made reference to a number of things that were changed that were subject to meet and confer, such as changes as it relates to drive cam. We didn't meet and confer. So there have been changes, but they're not in the labor agreement per se. There are a number of bulletins that went out in terms of drive cam violations and red light violations, those kinds of things. But those come out in the form of general bulletins.
Okay.
they're not really attachments or called side letters to the labor agreement.
And then I just wondered if I know that there are a number of layers of, operational procedures that you go through at the MTA because you have the cities and the unions. But because his letters specifically reference the Sunshine Ordinance, I wondered if you realized that if you have no documents, it still requires a response within 10 days saying that there are no documents.
Yes, I do now.
Oh,
That would be
but
much
at the-
better to address it that way, yes.
Okay, thank you.
Thank you.
Thank you. Is there a motion?
Dave?
No, I didn't have anything.
I do have a motion, but I have to get to the page. I would like to find the violation of 67.25A for the immediacy of the response. I'd like to propose a motion.
Is there a second?
Second.
Moved and seconded. Member Knebber.
I just want to, was it immediate disclosure request?
Oh, sorry.
Just want to make sure that we're clear on that.
They didn't respond at all.
Yeah.
So did I cite the wrong
I would
thing?
I would be more inclined for 6721B.
I think that's what I intended. I'm sorry. Thank you.
I'm sorry, 6721
B.
B?
B.
B as in boy?
Yes.
Okay. So 6725A is out. Is that correct? Discussion? Member Snyder?
I would propose an amendment to add 6727, failure to provide justification for withholding.
Can I ask a question? about-
Member Johnson?
Even though she said there are no documents,
But she's required under the ordinance to explain that to him and to do it within a certain amount of time.
Okay.
But for purposes of 6727, she has to say that. We can't provide you these because we don't have them.
and that would be the justification that she did not provide on time. Is that because she did talk to him, though it was very late. I'm not sure how that works.
Member Wolf, Member Knebber.
I would just remind us that she did testify that there may have been side letters or addendums in the past, and clearly the complaint is for requests between a 6-year period. So something obviously existed sometime.
Member Knebber?
Yeah, I mean, that's something that I'm troubling with. But going back to the original idea, I think that we can find for both 6721A because she failed to respond, and then also for 6727 because there was no justification for not giving an idea. So,
6721B, right?
sorry. Yeah, 6721B.
Further discussion? Mr. Threed?
Through the chair, just for clarification, 67.27 deals with justification for withholding of documents or public records, and I believe it deals specifically with a situation where the public records exist and they're not provided, but rather they're withheld, and then there must be some justification in writing according to these criteria.
Member Knebber?
I understand that. Thank you, DCA 3. But my idea of this one is that if there are those letters, other side things, even if they're invalidated, which he asked for all letters from 24 to whatever, 2004, even if they're invalidated, he asked for them, and there's no justification for having those ones withheld. that was my line of thought.
Further discussion. Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
Through the chair.
Member
Could we just
Knepper.
have a repeat of the motion?
Motion is to find violations of 67.21B for boy and 67.27.
Thank you.
Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Wolf? Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Okay, and this matter is referred to Education, Outreach, and Training. Mr. Clerk, could you call the next item, please?
The next item is item number 10. It's the determination of jurisdiction on complaint filed by Nick Pasquarello against the San Francisco Municipal Transportation Agency for allegedly not providing him with documents related to the Clipper program.
Is there a motion to accept jurisdiction?
I move we find jurisdiction.
Second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. That takes us to the substance of the complaint. Mr. Pasquarello?
Mr. Chair, I have submitted an email from Mr. Pasquarello asking for a continuance.
Okay. Is the respondent present? Is there a representative here from the Municipal Transportation Agency? Continuance has been requested. Do you have any objection? And we appreciate that you've stuck around this long, but there is a request for continuance. Do you have objection to that?
No, I just wish I would have known sooner.
Okay. Without objection from the task force, this matter is continued until our next regular meeting. Thank you very much for your attendance.
Just point of order. So that means in the next meeting we have already approved.
I'm sorry?
For the next meeting, we have already voted on jurisdiction, correct?
That's correct. Jurisdiction is established, and just the merits are continued to our next regular meeting. That would be February 22nd, I believe.
Mr. Chair, Mr. Pasquarello's request was a continuance to this matter to a future meeting of the SOTF.
Well, I believe February 22nd is in the future.
Hope so.
Could you read the next item, please?
The next item is item number 12, which is the determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly not providing him with a breakdown of the salaries and benefits of its employees.
Okay. I believe this should be requested, corrected to reflect the fact that both William and Robert Clark are listed as complainants. They both signed or put their names on the complaint form. Is there a motion to find jurisdiction?
I move we find jurisdiction.
Moved and seconded. Is there a discussion? Is there public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Wolf? Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. The respondent has requested a continuance. He slipped a note to us saying he is a caregiver for somebody in Marin County and had to leave at 6:30. Mr. Clark, does a continuance inconvenience you? Do you have objection to it?
Yes, I do have objection to it because I'm a street artist and I work and I pay for his salary and I can afford to be here to discuss this. And I've waited till now, and this is very short. It's not a complicated issue. And as a matter of fact, all I'm trying to do is find out what his salary is. and what the salary is of one of the other employees. And had he stayed, he could have given us that information here tonight. And I'm very upset that because you postponed the last
thank you.
meeting. Thank you.
Thank you. What is the will of the task force? Member Kneber?
Again, I'm always for moving forward on it, especially it's one thing if the complainant, I'm always on the side of the complainant, so if the complainant's ready to go forward, I'm always ready to.
Okay. I detect consensus for not continuing, for moving forward with this, so we shall do so. Mr. Clark, thank you for coming. You have 5 minutes.
Thank you for hearing us. Thank you, members. This is very simple. Several months ago, I've been trying to find out what the final paid expense salaries were for Mr. Lazar and for Miss Evelyn Russell, who worked for the Street Arts program for the year 9010. And I've been verbally asking for that information, and I haven't gotten it. And in a letter which I wrote to him on November 8th, I specifically asked him for a breakdown of the final expenses for salaries and employees, which he recorded in the controller's office, was $118,000, $759 in salaries, and $42,820. And what I asked for was the document specifically saying of those figures, what figures were hit, what salary was his, and what salary was Evelyn Russell's, and what salary was anyone else. And in the benefits, I was asking what were his benefits and what were her benefits. And he responded on November 22nd, and he sent me this letter in which I'd like to give you another copy here so you have it. But he says in response to, on number 4, he refers to that request. He says, in response, please find the enclosed 2 printouts, famous screens entitled blah, 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 blah. And I got those two documents, which are here. I think I presented it to you. But in those documents, that's exactly the same information I had gotten from the controller that I was asking him to expound on and give me the breakdown of. And neither one of those documents states, they just state the total of the 2 employees' salaries and benefits. They don't break down what the salaries and benefits are. And the reason why I'm trying to get this information is because Ms. Russell quit or was fired. They won't tell me back in February of last year, and so for a whole year we haven't had this employee. And I'm trying to get these figures so that I can address the budget, the present budget matters as we are having here. So I'm just, he said he responded to my request, which he did, but he responded by sending me the documents I already had, and that did not answer the questions that I was requesting from him. And if he had been here, I've been trying to get him to tell me what his salary was for that year, because then I could simply subtract his salary from the total figure, and I'd find out what Ms. Russell was paid, and the same thing with the benefits. And just for your information, the Arts Commission refuses to answer me that question. At the meeting we just had a couple of days ago, I was told by the Arts Commission, Mr. Kinsell, that I was not allowed to ask any questions under public comment on financial matters. We were talking about the budget, the next year's budget, and they told me that that I could not ask any questions, myself and my brother, and that if we did ask any questions, they were refusing to answer them. So I'm sorry to come here to ask you this trivial question, but I can't get this information from them, and I wish we could have gotten it tonight. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, the chair will again note that the respondent has left. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Snyder.
It seems pretty clear to me that Mr. Clark's request was fairly clear. He was looking for Howard Lazar's salary, Evelyn Russell's salary. What the commission produced was sort of a spreadsheet, which is on page 110 and 111 of our packet. And it appears that the Commission's argument for why they don't have to break that down into Mr. Lazar, break that spreadsheet down into Mr. Lazar and Mr. Russell's salary, is that to do so would be to create a new record. And that this argument's contained at 104 and 105 of our packet. They make it. The Arts Commission says that we don't have jurisdiction, but that's not. I don't think what they mean. What they mean is there's nothing in the Sunshine Ordinance that requires them to create a new record. And I actually have looked at the new record issue for something else in the past, and there is a doctrine which says that the government agencies aren't required to create a new record, and there's a lot of case law not very clear about what constitutes a new record. But it seems to me on the face of what we have in front of us that to just isolate one person's salary couldn't possibly constitute the creation of a new record, because there's no way the Commission doesn't have in their records somewhere Howard Lazar makes X dollars per year. That just doesn't seem possible to me. I mean, what they may be arguing, the Commission, is that here are the spreadsheets. We're giving you those. You can't require us to break these spreadsheets down into anything else. But that's not what the clerks did not ask for the spreadsheets. They asked for the salary. And I just find it hard to believe that the Commission doesn't have the salary listed somewhere. So I don't see how their new records argument could succeed. If they were here, they might be able to explain to us, how they don't have Mr. Lazar's salary broken out separately. I just don't see how they could argue that. And so it seems clear to me that the Arts Commission didn't provide the information requested, and that the information requested is public.
Mr. Kneber, Mr. Wolf, Member Chan.
I would add additionally that there is requirements for oral information,
right.
And I would find it even harder to believe that Mr. Lazar doesn't know his salary when asked, right. And I think that is a disclosable record.
Yep. Member Wolf and then Member Chan.
Yeah, I have to agree. They have to submit a budget every year like everybody else. They got to have it, some documentation of how they plan on spending the money that people like the Clarks, the complainants, and other artists are giving them. So, yeah.
Member Chan?
Yeah, I think the Arts Commission and Mr. Lazar's position is a civil service position, right? And there should be a document on the salary of that civil service, and clearly they're trying to avoid that.
Member Johnson.
Through the chair, Mr. Threet might know this. There is access to some salaries on the website. Would that include the Arts Commission salary as well? Yeah. Do you know?
Mr. Threet?
Excuse me, through the chair. I was having an exchange with the administrator, and I apologize. I didn't hear the full question.
There is a place on the city website that lists salaries of certain employees of the city. Would Mr. Lazar's salary be included among those? Do you know?
I'm not aware of such a place on the city's website. I do know that there have been public records requests, and for instance, the Chronicle one year created a database that included every city employee's salary and benefits, but I'm not sure that is a database that's published on a city website at any place.
Okay.
But the information is available somewhere.
Okay, thank you. Thank you.
Member Chan?
Actually, the person is not here. We could just ask Mr. Lazar, what is your civil service classification? And you could just go to the website, or actually they could produce it like right away. He's not here.
At this time, since the respondent is not here, at this time the complainant has 3 minutes to make any concluding remarks.
Thank
Thank you. I agree with several of the points you made. One of the things I want to address is one of the things I'm trying to find out is what Miss Evelyn Russell's salary and benefits was for the year of 9-10, because we have been unable to get that information because it's relevant to the fee setting procedure, which you guys are all familiar with. So, I mean, that's one of the objections I have, is that he hasn't provided me with the records stating exactly what she made for that year. And I want to say their argument about a new record, I found very offensive, because the only way they come up with this total at the end of the year is to add up the records that they have throughout the year to show what they paid the staff. And so the fact that they use that to say, well, we're not required to create a new record, I found very elusive, because the records are in the Arts Commission of who they pay their staff. They're there. They just refuse to cooperate with me. And so, I think that it was one of the points I wanted to make, which was that the way they figured that final figure of $118,000 and $42,000 was they added all those salaries together. And how did they add those get that final figure unless they knew what each salary was? So I think this is a good example for you to see that, and I'm serious. I went into the meeting we were having on next year's budget, and I specifically tried to ask them about these salaries again, and I was told that I was not allowed to ask any questions under public comment, and that they would refuse to answer any questions about the finances if I asked them. And I'm at a loss, because under the Sunshine Ordinance it says that a committee may, on items that are that are not on the agenda, that the commission may answer the questions of a person who's discussing something that's not on the agenda. But now I'm being told that they don't have to. I can't ask a question about an item on the agenda. So I'm going to probably be coming back in front of you again on some other issues in regards to this, because that's the attitude that they have. So all I can say is I wish we could have got to this earlier, because I would have found out what Mr. Lazar's salary is, maybe from him. And if we could, and then I would have subtracted that, and I would have found out what Ms. Russell's salary is. Because the reason why is because the Art Commission represented to the full Board of Supervisors that Ms. Russell was paid for a full year's salary, and she wasn't paid for a full year's salary. And that's why I'm trying to get this information. Thank you.
Thank you. Matter is back with the task force. Member Johnson.
Mr. Clark, did you ask? Mr. Lazar was here earlier. I saw him.
Right.
Did you ask him what his salary was at this time or at any other time directly?
I've asked him personally, face to face, and I've also asked him in emails just to tell me what his and her what they were paid.
And what was his?
I never got an answer to the email, and that's why I made the document request in this case.
Did you ask him this evening, or
no?
Did you not
No, we're
speak?
not speaking to each other anymore. So I mean, we've known each other for 40 years, but because of the way I'm being treated by the Arts Commission, I don't feel like I want to talk to him, and he's not talking to me anymore.
Thank you. I have some concerns that it would be oral information, and he was here. What do we do about that? I mean, he was here and could have provided the information and then left.
Well, Member Snyder, Member Kneber.
I would say he hasn't provided the information, and even if he had now, it would still be too late. Mm-hmm. I mean, I should correct. Let me be more precise. He would still be. He would have. It would have. Too much time would have passed in order for us to not find that there was a delay in excess of what the ordinance allows. I don't know if he had provided the information orally here, then we'd have a question to deal with, but he didn't, so we don't.
What about that he was here? Could it be that it was willful?
I think that's a little.
It seems like a little bit of a stretch. I wanted to make a motion. Can I make a motion?
Go ahead, please.
Yeah, I would just move to find violation of 6721B, 6721C, and 6726, which governs withholding being kept to a minimum.
What's C?
Of course, I just put them away. B is, well, go ahead. Oh, B, well, hold on. Yeah, if you have it in front of you.
I got it.
Yeah, B is the 10 days. C is the assisting the requester in identifying. The reason I'm including C in assisting the requester is, it's clear the records are there, and the commission could have done something to approach Mr. Clark and say, look, we have these numbers. What do you want us to do with them to get you the information you want?
Is there a second?
I second.
Moved and seconded. Further discussion. Member Wolf, Member Knebber.
Yeah, this would have been a perfect opportunity to again try to avail ourselves of using Section 6721E. I think what might be helpful for the public is if they would contact our office and report whether the custodians refuse to give the information, that we can then say contact the supervisor of public records, because then the supervisor of public records has the authority to go and get those records and provide it on a more authoritative level, and then 6721E provides us with a tremendous amount of application to be able to get the public its needs met.
Member Knebber?
Yeah, I just want to address this idea about the oral information. Even if he was, I agree with Member Steiner, even if he was here, it has to do with the repeated attempts to get the information, and if in no other way, I believe that Mr. Lazar could orally have given that information. So I think we can apply it to all those attempts when he's been asked in person, asked here. So I don't think that we need to bring in that he was here and could have answered it here into our deliberation about that.
Is there any public comment on this item? No, sir. Is there public comment on this item? Seeing none, public comment is closed. Further discussion. Roll call, please.
Point of order, could we have a reading of the motion again?
Okay, the motion is to find violations of 67.21B, C, and 67.26.
Thank you.
On the motion, Member Snyder.
Aye.
Snyder, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Wolf. Wolf, aye. Member Chan. Chan, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Yeah, Mr. Chair, we have 8 ayes.
Thank you. Could you read the next item, please?
Where does
this? I'm sorry. This goes to compliance and amendments.
Thank you, Mr. Chair.
Chair, can I?
Next item, please.
Next item is determination of jurisdiction on complaint filed by Jason Grant Gaza against the Haight Ashbury Free Clinics for not providing him with documents related to 2 visits he made in 2010.
Is there a motion to accept jurisdiction?
I move we find jurisdiction.
Moved and seconded. Is there discussion? Is there public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Snyder.
Aye.
Snyder, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Wolf. Wolf, aye. Member Chan. Chan, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Okay. Before we proceed, the chair wishes to let everybody know that Member Snyder, who is our voting member attorney, has had to leave. Mr. Threet is about to leave. We complainant and respondents are notified that we will be without professional attorneys' advice here or opinions. Okay, it's unacceptable. Do you wish us to, in light of that, sir, do you wish us to proceed now with your complaint?
I don't know. I have to have the 4 members that are missing and whose vote will count against me explain to me that before we proceed, because
Okay.
I want to be sure I'm not thrown into a rigged process.
Okay, in explanation of that particular question, Mr. Snyder has had to leave. He has family obligations. Member Cawthon has been away for medical reasons.
That doesn't answer why short vote is an automatic no.
Okay, she is excused. And as you know, there are two vacancies on the task force.
Okay, that does not answer the question as to why their votes are automatically no against me. I'm still waiting for that answer.
Okay. That is the interpretation we have had so far from the city attorney's office. It is the procedure we have followed to this point. This may change sometime in the future. You heard the discussion we have earlier. For now, that is what we're going by, sir.
Mm-hmm. And I've also, in the past, been here and explained to you about the false process and that you guys should step aside.
Okay, Mr. Garza, do you wish us to proceed now with your complaint without?
What are my choices? What is my Hobbesian choice that I have here?
Your choices are yes and no.
I'd like to understand. If I proceed with the yes, does that mean that all members that are sitting on here, all 11 will vote, and that the ones that aren't here will vote having listened to my arguments?
Sir,
will I be afforded due process?
Sir, we have 7 members here. If your complaint proceeds, 7 members will vote.
Okay, well, those 7 members constitute the total voting people, and do I only have to get a majority of those 7 members, 4 out of 7 to win,
You will need 6 out of 7 to win.
No, that was not my question. The majority of 7 is 4 out of 7, not 6.
Sir, I have explained the rule to you. In order for a motion to pass, a substantive motion, not a procedural motion, but for a substantive motion to pass, 6 affirmative votes are required.
And I have shown you where that is against my due process, and we've had other people get up and
Mr. Garza,
explain that.
Mr. Garza, you asked me what rules.
Please.
Mr. Garza, you asked me what rules we are going by. I have told you what rules you are going by. Do you wish to proceed? Yes or no?
I'm still not clear. Please explain it to me. I am a disabled person, and I do not understand. So under ADA, I would like an interpreter because I do not understand. My questions are not being answered appropriately for my disability. My disability, let me finish, please, is that I have an adjustment disorder. I cannot adjust to disorder, or I'm a very well-adjusted individual in a very maladjusted society, whichever definition you want to take.
Okay,
Unfortunately, I have asked the appropriate questions, and I have not been given the appropriate answers. I have been given answers which do not address the issue or the laws or anything else, policy, but certainly not anything that has to do with my constitutional rights or due process, which is what you're here for. But policy I've been given. Interpretation I've been given.
That's correct.
But not
and
law.
That's all we have to go by.
No, I thought you had to go by the law.
Well,
isn't this the Sunshine Ordinance and the law?
These are the interpretations of the law that have been provided to us by the city attorney.
Correct. Interpretations, but not necessarily the law.
Well,
so I'm asking you to fulfill the law.
It's all we have to go by, sir.
And how? Why
are you an attorney, Mr. Garza?
No.
Then how do you tell us what the law is?
The same way that you tell me what the law is on relying on somebody else's opinion.
Well, okay, but we have legal opinion so far. We are going to be re-examining that opinion. We are going to be.
Well, unfortunately, if you cannot tell me that 4 out of 7 will win my thing tonight.
I have explained to you, sir, the rules we are going to go by tonight.
And I have explained to you that I have an adjustment disability.
I am the chair, sir. I am the chair of this meeting, sir. Okay, if you wish to have an interpreter, you should have told us that earlier. You should have arranged for that earlier.
As a matter of fact, I did, sir. Earlier, I asked that the full board be here. You were given notice, and if there was any problem, for me to be notified. Why was I not?
Mr. Garza, if you wish an interpreter,
no, sir, I wish an answer to my question
that
I just asked you.
You wish an interpreter for this proceeding, in which case we will continue it.
I wish to be answered the question as to why, when I notified your administrator that I demanded the full board be here, and if there was any problem with the full board being here, all members, so that I would not be denied process, that I would be informed before I got here. Why did that not happen, Mr. Chair?
I cannot answer that.
Who can, Mr. Chair, if you cannot?
All I can do is, Mr. Garza, All I can do is tell you now why there are 4 empty seats here. And I have just told you that. I will repeat it if you like.
Now, I understand that, but that does not answer my question as to why, given the notice that I gave the administrator since the inception of this case, 12, and I do have it here, I do have it in black and white to you, specifically stating that it is to be heard in front of the full board, and if there's any problem with this and it not being a possibility, to be contacted before. Why was I not responded?
Mr. Rustum?
Mr. Chair, on at least 4 to 5 times I have told Mr. Garza that there is no guarantee that they will have a full, all the members of the task force hearing his case.
Thank you.
Pardon me, say that again, I didn't hear it. I want it for the record.
Mr. Rustum's response is on at least 4 or 5 occasions. He has informed you that there can be no guarantee that a full board, a full task force
No,
will
that
be
is
present.
false. That was not what I was informed.
Well,
Okay, now, at this point,
Mr. Garza, do you wish to proceed with your matter?
well, let me re-ask the question. If 4 of you rule in my favor, which is the majority of the people here, will I still be thwarted by bad process?
Mr. Garza, I have explained to you that...
Is that a yes or a no, sir?
If only 4...
Out of these 7.
Out of the 7, if only 4 vote in favor of your complaint, to uphold your complaint, the motion will fail.
So I will be thwarted with the majority of the people here.
That's correct. It will require a vote of at least 6. That is the rule we've been going by. It's not changed yet. We may change it in the future.
So now let me ask you the next question then, please.
Go ahead.
At this next, if I continue this, you will guarantee that all 11 members will be here to hear it?
No, I cannot guarantee that, sir.
So this continuation could go on for an entire 17, 18 hearings, or whatever the person said had happened when there was never a full board here. And it would violate my 45-day rule as far as receiving
Mr.
the time
Garza,
of thing.
Mr. Garza, I have just asked you if you wish your hearing to proceed. If you can make that choice now, and the 45-day rule would have been met.
Not if I've been thwarted by process and 4 people vote again. I don't win the. 4 people vote against me. It falls.
The 4 votes can't be.
Correct. So
4
no.
votes won't be known if your hearing doesn't proceed.
Correct. But 3 that aren't here will be automatic no's.
Mr. Garza, you don't know that. I am asking you once more.
Yes, I do know that the 3 that aren't here will be automatic
Once more
no's.
and for the final time, sir, I am asking you, do you wish your hearing to proceed now?
My question remains.
Yes or no?
If my hearing is proceeded, will the full board be there to hear it when it's continued to?
There's no guarantee.
We cannot guarantee
There's
that one way or
never a
the other.
guarantee.
There's no rule
never
that
a
your
guarantee in
complaint has to be
anything.
heard in front of a full board.
Then there's no rule that I will be afforded due process, because apparently the process doesn't work properly. So I cannot answer your question, sir. I'm sorry. You're going to have to do whatever you're going to decide to do.
The chair will entertain a motion to table this matter.
I move we table this matter.
Second.
Now, what does that mean? When does it get off the table?
You want to explain Robert's rule?
You don't need to respond.
There is no discussion on a motion to table. Roll call, please.
On the motion, Member Snyder? Snyder excuse. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Thank you. Mr. Garza, if you wish this matter to be brought back, you must do so for the next regular task force meeting, which is to be held February 22nd.
I must do what, sir?
You
Specifically?
must request that the matter be brought back, put on the agenda for that meeting.
And at that particular request, I can ask if the full board will be there to hear that.
You can ask, but again, the answer will be the same. We cannot guarantee it one way or the other.
No, I understand that you can't guarantee due process, but you can guarantee by not giving me what is correct, undue process, and thwarting me. That I do understand quite clearly, and I hope it's on the record.
Thank you. Ma'am?
That means
Please step forward to the microphone and identify yourself.
Vitka Eisen, I'm the interim CEO of Haight-Ashbury Free Clinic. And I need to inform you that we cannot be here on February 22nd.
Okay.
We have both, the other staff member and I have an obligation for the job on that period of time. So,
Excuse me, Mr. Garza.
so I would-
You will
I'd
be
like
silent,
to-
please.
my desire is to resolve the matter and to certainly have Mr. Garza's needs met, but I know in advance that we can't be here on that date. So if there's a continuance, it would need to be to the following meeting, or I don't know if there's another venue in which we can resolve it. I'd hand him his medical record tonight if he signs a release.
I understand.
Yeah, so
And there is nobody besides the two of you here tonight who is knowledgeable on this matter and who could attend a meeting if it was rescheduled to February 22nd?
I have to say no.
Okay.
Yeah. I believe it's my responsibility to respond.
Okay. We'll
as a
take that
CEO.
under advisement,
Okay.
and perhaps if it is rescheduled for our next meeting, perhaps we can continue it for a month.
Okay. Yeah, I mean, I'll certainly do everything I can. It's just one of those strange situations.
Thank you for
we're in
letting
training together. So
Thank you for letting us know, and thank you for staying here this long.
Okay, no problem. Thank you.
Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair. The next item is determination of jurisdiction on complaint filed by Bruce McClellan against the Recreation and Park Department for allegedly not releasing the Store Lake lease.
Is there a motion to find jurisdiction?
Mr. Chair, Mr. McClellan has made a correction to the complaint, which is on the last page of the handout.
Is that on the last page of the? Oh, okay.
Excuse me, I know it's not my turn to go, but department staff has not seen any amended complaint.
I'm sorry?
We haven't seen the amended complaint, and I would appreciate the opportunity to look at it. Thank you.
Okay. For the moment, we will. Is there a motion to find jurisdiction in this matter?
So moved.
Second.
Moves and seconded. Discussion. Is there public comment on the jurisdiction question? Seeing none, roll call, please.
Jurisdiction member Maddie.
Aye.
Maddie, I member Washburn.
Aye.
Washburn, I member Knepper.
Aye.
Knepper, I member Wolf.
Aye.
Wolf, I member Chan. Chan, I member Johnson.
Aye.
Johnson, I member Nee.
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Thank you. This takes us to substance. Sir? Okay. Mr. McClellan, please approach. Thank you for coming, and thank you for sticking around. You have 5 minutes.
Actually, before
The microphone.
before I start, that change was not. I mean, it was maybe I miswrote it, but it was always for the same. It was the proposal that was submitted, and not the lease. The lease has been released by Rec and Park. So, just wanted to say that. Okay.
So that the contract has been awarded?
It's getting close. It's before the Board of Supervisors tomorrow.
Mhm.
So, it's anyway. Basically, I'll start my 5 minute or whatever.
Please start the 5 minutes now.
I'm Bruce McClellan, president of the Stowe Lake Corporation. We've met before. My family's been out there 67 years. You've heard a lot of this before. The reason I'm before you again is not to belabor an issue that we've already talked about. My uncle, Cal Tilden, in your item number 10042, he submitted his complaint and his request prior to the approval of the lease by the Recreation and Park Department, and you ruled at your last meeting that the Recreation and Park Department, and we had a whole discussion about RFQs versus RFPs, the selectivity. Member Wolf was going to bring his computer, maybe this time, I don't know. In any event, The complaint I'm making now, I filed it after the Recreation and Park Department had approved the lease. So that's a hurdle that hadn't been met on the last issue that you had before you. Now that the Rec and Park Department has approved the lease is approved, and I maintain that the bid that has been submitted for this approval should be released for my review. It is now before the before the Board of Supervisors, Budget and Finance, specifically tomorrow, and they're voting on just authorizing the signature. But the approval already took place at the Rec and Park level. On the December 2nd meeting at the Recreation and Park Department, they put out an agenda of items that are going to be discussed at that meeting. And the agenda item pertaining to the Stowe Lake concession was that the heading on it was approval of contract. That's what the heading was. So they approved the contract. It's now before the Board of Supervisors for authorization to sign the contract. And as a matter of fact, Supervisor Marr introduced legislation number 101416, authorizing the general manager to sign the lease. So all of the Board of Supervisors is authorizing the signature, but the approval of the lease took place. And so then, by way of a little background, the law, and I'm not a lawyer, so I don't know, but it appears to me that if it's an RFQ, which is the case here, as opposed to an RFP, it leaves it up to the entity, in this case, Recreation and Park Department, whether they want to release the information or not. In this case, the information has been released piecemeal. So some of the information has been released. I maintain it's the information that advanced their cause to approve the Ortega lease. And then the information that might be damaging to their cause has not been released. So it's not really a question of the release or the non-release of this bid package that was submitted. It's the selective release, which I maintain is it could border on fraud, I think, because how can I make any public comment? How can I protest a bid if I can't see it? And they are maintaining that even though they have approved the lease document, they don't want to release it to me until after the Board of Supervisors has authorized the signature. So it's approved, the signature comes through. So then what do I do afterwards? So all I'm looking for is a copy of the bid that was submitted. Here it is. It's the night before. In 14 hours, the Budget and Finance Committee is going to be looking at it. But that's basically what I'm looking for. And again, the difference between this and what you talked about at the last meeting with Tilden versus Recreation and Park is this is filed after the Recreation and Park Department approved the lease. That was their words. They approved the lease, and his complaint was filed prior to the approval. So that's it. Thank you for your time.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, respondent, please.
Nick Kinsey, Assistant Director of Property and Concessions Management for the department. Feels a little bit like deja vu up here. As we've spoken about before, Section 67.24E1 of the San Francisco Administrative Code expressly permits departments to withhold the requested information until the final contract award has been made. Charter Section 9.118 of the San Francisco Charter stipulates that all contracts that exceed $1 million in total value or 10 years in length shall be approved by the shall require the approval of the Board of Supervisors. The contract that Mr. McClellan is referencing does require Board of Supervisors approval pursuant to Charter Section 9.118, and accordingly has been forwarded to the Board of Supervisors for their approval. Mr. McClellan misspoke a small bit when he mentioned that our commission agenda said that we were approving the lease. That's actually not how we handle matters. When a lease will be forwarded to the Board of Supervisors, our commission recommends that the Board of Supervisors approves. And if you actually go back, I don't have that language with me at the moment because I did not know that this was going to be brought up. But if you look at our agenda language for that item, it would say that the Recreation and Parks Commission recommends that the Board of Supervisors approves a lease with Ortega Family Enterprises. So very clear that the approval will happen at the Board of Supervisors. And again, that's pursuant to the city charter. The department has no jurisdiction in it. And seeing as section 67.24E1 is very explicit that the information shall be mandated to be released at the time of final contract award, we would request that this complaint be expeditiously rejected.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter with the task force. Member Wolf.
Mr. Kinsey, so I'm actively looking at tomorrow's agenda for Budget and Finance Committee. First of all, I don't know who created the PDF of the documents, but it's not searchable, and I don't know. There's some violation in there for it not being searchable.
Those documents are created by the clerk of the board's office.
Okay, so I'll take that up with them because I have no way to search. I can't find how many times RFQ is mentioned in there. But in the attachment of the agenda, is the RFQ contained in that?
No, it is not.
Looking like Exhibit C, evaluation criteria, and it gives points.
That's the budget analyst report. The budget analyst chose to include that in their report, but the department introduced package does not have the RFQ as part of that.
Let me just see here what this says here.
The department has no control over what is placed or not placed in the budget analyst report.
It doesn't say that it's the budget analyst report. It says Department, Recreations, Parks Department. Executive summary. It mentions your name several times.
I believe that's the budget analyst report. If you're clicking it off of the Board of Supervisors committee webpage.
Oh, okay.
Yeah,
I see here at the bottom of the page it says Budget Legislative Analyst. Okay, I gotcha. So the Board of Supervisors will not see the RFQ at all?
No, and that's not standard practice that information be shown to them. The Board of Supervisors, pursuant to Section 9.118 of the Charter, has pursuant to Section 3.114 of the Charter, is only allowed to take an up or down vote on contracts. They are not allowed to evaluate or to consider other respondents. The question before them is solely, is this a good deal for the city, and whether or not the contract should be awarded to this entity. It's not, should another entity be given this
Let me ask you another question. Let's take the Board of Supervisors out of the picture. Did the budget analyst see the RFQ?
The budget analyst did not see the responses.
So where did they get all this information from?
We worked with them to develop that report. They submitted requests for information. We released the information that we felt was appropriate to release. There's information that they asked for that was not released because the department feels that it is not in our best interest to release that.
When was that information released to the budget analyst?
Over the preceding 2 weeks or so.
Okay, was that, do you realize that information is public?
Absolutely.
And was that made available to Mr. Tilden or to Mr. McClellan?
I think that most of the information that they've requested for actually has been already released. I don't know of any information that had not previously been released.
Yeah.
Yeah.
I mean, it talks about like the RPD's competitive RFQ selection process, neither required nor considered the MAG or the percentage rental rates. How could they know that?
Because they responded to the RFQ, which didn't have mags or percentage rates as part of the RFQ.
No. How did the budget analyst know about that?
They asked me, and I told them.
Okay. Mr. McClellan, do you know about this document for tomorrow?
I've seen bits and pieces. This is the problem that I've been having, the exact line of your questioning, that certain bits of this information are being released to the press and other pieces of information aren't. When the RFQ and the original bids first were received by the Rec and Park Department, we've been open with our bid. Anyone who wanted to see ours is possible. Of course, that's.
I realize that, and I know what we're talking about with the RFQ, and I do have to apologize. I've had a family matter for the past 3 weeks, so I have not been able to do my own diligence, and I apologize for that, and I feel a little bad about that. But I'm looking at 30 pages of document that is pretty explicit about items that would be or could be contained in an RFQ. Not saying that it is the RFQ. What I'm interested in is really like, this looks like Budget and Legislative Analyst's Office actually got a copy of it. There's just such detailed information.
There's been selective information given out all the way through the process.
But have you gotten any of the information? Really, the question for me at this point is, if the Budget Legislative Analyst got this information from Rec and Park, this same information would then be considered public, and you would be able to get it. Did you get that? Did you request it?
I have seen the budget analyst report that you're looking at, the one that's going to be.
But did you get the information that they got to make the report prior to, or at the same time they got it?
No. For example, when Mr. Kinsey says that he responded to their questions, if you the newspaper articles, what's in the public domain, what the budget analysts received. One example is a comparison of the capital improvements that they'll be talking about tomorrow that I had proposed versus the Ortega proposal. And what has been told to the public is that I proposed $23,000 worth of capital improvements to the boathouse, and what the Ortega proposal said was that they would pay $230,000, basically 10 times what my proposal was, and it's just a flat-out fabrication. In my proposal, when you read my proposal, the numbers I proposed, I won't get into all the details, but basically in my proposal, written in my proposal, it's significantly higher than the $23,000, but since my proposal has been held back from anyone being able to look at it, all they can do is rely on the information provided by staff at the Recreation and Park Department to make their comparison. And as a result, I wanted to go see. I just wanted to see. I'm just trying to level the playing field and say I'd like to see what the original Ortega proposal contained.
Okay.
Who is it? That's all I'm trying to do.
Okay, I got it. Mr. Kinsey, can I ask you one question? I'm a little confused because in the Budget and Legislative Analyst report, it says, according to Mr. Nicholas Kinsey, this is on page 1-3. It's on page 6, actually. And I know people. This isn't in our. This is documents that I pulled in. It says, according to Mr. Nicholas Kinsey, RPD, Assistant Director of Property and Concession Management, RPD issued 4 competitive requests for proposals to operate the Stowe Lake Boathouse, 2 in 2006, 1 in 2008, and 1 in 2009. According to RPD, quote, on each occasion, the department either received no responsive bidders or was otherwise unable to successfully select a respondent on each of those occasions. And next paragraph, instead of issuing a 5th RFP on February 4th to 2010, RPD issued a request for qualifications soliciting an operator for the Stowe Lake Boathouse. Why the change?
I guess I would posit I'm not sure how that's germane to our conversation here.
Because we're trying to determine whether there's a difference between RFQ and an RFP, and it's very explicit that at one point you're using an RFP process, which is explicit in the Sunshine Ordinance, and RFQ is not.
Okay, so we put this out to bid on 4 occasions, twice in 2006, once in 2008, once in 2009. And on each of those occasions, what we found was we did not receive a response from a bidder who was willing to put in the level of capital investment at the site that the department felt was necessary for the site. So we decided to change things and do things differently, and not include the financial terms, and solely look for a respondent willing to invest in the subject property. That was a policy decision made by our commission, was a policy decision they are permitted to make, and that's why on this 5th occasion, rather than going forward with the same process that we have 4 times and hoping that something would be different on the 5th, we decided that if what we really want at the subject property is capital investment, perhaps we should be more explicit in asking for that. And so that's the difference.
Okay.
Member Johnson?
Just to the task force, how do I put this? Mr. McClellan's argument, no offense to you, Rec and Parks representative here, so forgive me, but you're arguing that the Rec and Park approval would constitute an award, and I don't want to set that precedent because I wouldn't want Rec and Park to be able to award without the Board of Supervisors reviewing it. Now, Budget and Finance Committee is not the final approval. Doesn't it initially then have to go to the board? So I hope you plan to attend. You are indeed caught up in the politicized process that goes on at City Hall, and I apologize for that.
I'm learning.
But you're definitely going to have to go before budget, because once the public comment happens at budget, you won't be able to speak at the full board. But I would be reluctant to change our former ruling, even though they're, clearly with 5 RFPs, they were looking for I don't know what. But in order to rule based on your reasoning, it would be difficult. They've sent it to 944 people. That's a lot. But in order to, we need to have the checks and balances, though I know they're not operating. It seems like they're intentionally trying to shut somebody else. I'm not suggesting we're not seeing you or hearing what you're saying, but the word in the Sunshine Ordinance says awarded. That it doesn't have to be released until it's awarded. And I would like to have that be something that the Board of Supervisors has to do, not something that we say Rec and Park gets to do.
Member Wolf?
Yeah, I agree with you, Member Johnson. My intention for going down this line is to separate that the RFQ is not part of the RFP process, that there is some separation, and again, my wholehearted apologies for not being able to do a deeper investigation on this, but I did get positive responses from city departments that in fact an RFQ is not an RFP and it should not be used by any department in the city, whether it be enterprise or a city department under, in the mayor's under the mayor. So I've yet to get to continue that investigation. I hope to, so that it'll bring some clarity to our decisions in the future, because we'll need it. I'm sure this isn't the first time it happened. It's not going to be the last. So it's the best I can offer. I agree. I mean, either way, Rec and Park is doing the diligence of making sure that it gets passed by the Board of Supervisors. It's following the correct process, at least for the getting it approved. So I would say that the the process is being adhered to. What I'm not sure about is whether the process that we used was correct or not.
Member Johnson.
Other thing I want to point out is I did get some more information from, after you were talking about the controller from the city administrator's office, who said that the reason they didn't respond to me before was because there was some things going on with the mayor, who was the city administrator. And they did send me a guideline that said there was a difference between an RFQ and an RFP. And I would like to point out, I don't know where this page was that you were just on, 1-3, that even Mr. Kinsey himself indicates there's a difference. You see? According to Mr. Kinsey, the RFPs didn't work, so we switched to an RFQ. And I'd like to say that that's evidence that they also consider them to be different.
Okay, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks.
Nick Kinsey, Recreation Parks Department. I think that over the past, 5 months now, we've been to this issue quite thoroughly. This task force has weighed in on no less than 2 occasions now, saying that the department was permitted to withhold the information. The respondent says that since his uncle's complaint was resolved, that facts have changed. They have not. The commission heard the item on December 2nd. The task force settled the Cal Tilden versus Rec Park on January 4th, so the facts are materially exactly the same. And we would ask that the complaint be rejected. Thank you.
Thank you. Mr. McClellan?
To that last comment, I would just say that December 2nd was the date that the Recreation and Park Department, as a commission, approved the lease, and the Tilden complaint was heard and settled by all of you in January, but it was filed prior to the complaint. And so I'm just going on the record as saying, I look at it as they have approved the lease. It's now just in for signature with the Board of Supervisors. I would say also that, just because I have my 3 minutes here, the process, and I've been making the rounds and talking to the supervisors and talking to people, and it's the same thing. You start out trying to explain what's going on, and there's so many moving parts and facts in this whole case. It's really my first endeavor at talking to government and politics and doing all this stuff, but the staff at Recreation and Park Department has hidden my bid, the bid that I delivered, and they're doing their own interpretations. No one came and talked to me about what I'd proposed. So whether it's the Rec and Park Commission, or it's the Harvey Rose and the budget analysts, or it's the Board of Supervisors, no one gets to look at the bid that I proposed, that I submitted. And aside from the obvious factors that I'll bring up tomorrow, the fact that I proposed $1.5 million in guaranteed minimum higher than the bid they're about to accept, the fact that the bid they're about to accept is offering less rent than I'm paying currently on my 20-year-old lease. When they put their PowerPoint presentation together, they compared boats. They had a drawing of a rowboat that the new bidder is going to submit. And for my fleet, instead of the brand new electric motorboats that I proposed in my bid, they came out and took a picture of my workboat that we took out of service 10 years ago because it was in such terrible shape. And the day they took the picture of the boat, we had just picked up car batteries off the bottom of the lake. And so you have this boat with no seats in it with car batteries, and that was their comparison of the way I run things out there. And so it's really more of an indictment against the city and the process. I'm just the unlucky guy who's in the middle of this right now. And so all I'm doing, since they do have the ability to release this RFQ if they want to. They're not required to. I understand that, but at least then I can see what was in it, because I suspect that there's a lot more problems with it, and down the road after this is approved by by everybody and signed into place, I think I'm going to find that there probably was some fraud, because the representations in the lease are not what was in there, but there's no way for me to find out now.
Thank you. The matter is back with the task force. Is there a motion? Member Wolf?
I just have one more question, if you don't mind. Mr. Kinsey, has Stowe Lake Boathouse LLC moved in yet? Is there any work being done in there at all?
No.
It's empty, nothing's happening?
No, the Stowe Lake Corporation continues to operate the concession.
Okay, great. Thank you.
Is there a motion? Seeing none, this matter is concluded. Thank you both for attending. Yes?
What does that mean if there's no motion?
I mean, if there is no motion, the matter is concluded. There is no finding by the task force.
It would have to be a new
Thank you for your time.
Thank you for yours.
Feel free to stop by Buck Tavern at Market and Goff. That's what Chris Daly owns. Every Friday night, there's quite a number of people there who could give you an earful.
Also, I was a member of the Beach Chalet group back in the late 80s, and I know all about this process. So I'd be happy to tell you my story. It's quite interesting.
At some point, I've got to believe, I have so many people who come out and talk to me. At some point, they're going to unfortunately, thank you very much.
Thank you. Items 18 and 19 involve minutes that we have not received. Without objection, those matters are both continued to our next regular meeting. Mr. Clerk, could you call item 20, please?
Item 20 is the report from the Complaint Committee meeting of January 11, 2011.
Mr. Chair, we had two complaints came before us, and we approved both of them to be, we found jurisdiction in both of them, I believe.
Okay.
That's the interim report.
Thank you. The chair will note there is nobody in the public comment in the public section. Next item, please.
Item 20 is the report. 21 is the report from the Compliance and Amendments Committee meeting of January 11, 2011.
Chair Washburn.
At our meeting, we reviewed Member Snyder's analysis of the proposed Ethics Commission regulations regarding handling sunshine matters, and we noted that there some how they handle matters that we forward to them was not addressed. So Member Snyder was going to look at that, and we continue that item to the next meeting. I don't believe there was anything else on the agenda that day.
That's correct.
Okay.
Again, the public section is empty. Next item, please.
Item 22 is the report from the Education Outreach and Training Committee meeting of January 13, 2011.
Member Chan?
Yeah, we talked about sunshine being in the Facebook. And I guess we wanted the city attorney to have an opinion on that. And I think only one member could either sign in and respond to that Facebook if we create a Facebook page.
Because Chair Need changed the number of members, it makes it a little bit hard on us. Since there's only 3, 2 is a quorum, and we used to go 2 to trainings. I understand why, but just...
Well, there were 5, actually, and then...
and I was 3.
It's three, and that was necessary because member Williams resigned.
Right.
And second, we discussed about having other cities and or counties that have similar sunshine ordinance to invite them to the EOT to talk about their sunshine. And we exchange, I guess, exchange information with each other. And third, outreach for me, right? Outreach for the ethnic media. So we're trying to do that. And then fourth, outreach to newspapers. We delegate duties with the members to go out there and either connect with the newspaper or media to get outreach. And that's.
Okay. I might also suggest radio and TV news departments. Particularly, I think Channel 7 has at times shown an interest in getting public records or attending a public meeting. And at one time or another, any or all of them could come up against a public records or a public meeting issue. So certainly apprising them that we're here, and we'd welcome any input they want to give us, and we'd welcome any questions they have. I think it's a good idea. Also Bay City News and some of the other websites such as baycitizen.org, sfpublicpress.org, bogcityjournal.com.
I think previously it's been distributed to the EOT, the list of medias, but I know I got one, but the new members didn't get any. You didn't get that.
No,
we have a
but
list of.
I read SF Usual Suspects every day.
Yeah. Yeah, but that's a.
Yeah, but they listed on the side.
Chris, do you remember that we distribute?
That's a lobbyist.
I guess a list of medias in San Francisco.
Through the chair, yes.
Okay, so.
Okay.
I think we should, I guess, get it to the new members so we could get an outreach on that. That's concluded.
Also, you have a presentation planned for March at the local homeless shelter.
Oh yeah, we have a presentation scheduled in March.
Excellent.
And that will conclude my report.
Thank you very much. The chair will again note the audience section is empty. Next item, please.
Next item is the administrator's report. Mr. Chair, there wasn't a report in the packet because of the fast turnaround rate with Friday and Tuesday. However, we have only 4 new complaints. So the February agenda will be 4 plus today's 2, 6.
Getting on top of things.
Thank you. Any announcements, comments, questions, et cetera? Member Wolf.
Yeah, I want to, I feel really remiss about not really reading Section 6721E because, our process for being able to carry out public disclosure complaints, being able to order people to produce those documents, and then having a actual enforcement procedure to be able to do that does not include the Ethics Commission is right there in front of us. And it also allows for the Superior Court to be involved, and it doesn't say who needs to contact the Superior Court. It just states that that if a custodian of a public record refuses to comply, the Superior Court shall have jurisdiction to order compliance. So I think that, maybe we should look at it a little bit further. Maybe Compliance and Amendments Committee can discuss it a little bit. Maybe we can get DCA 3 involved and Member Snyder, because I think when you look at this and then you continue to read about administrative remedies, it doesn't specifically talk about the complainant. It talks about just a process. The purpose of the Ethics Commission is to deal with willful failure. That's what the ethics process is for, and that's at the very, very bottom of in a completely different section. So I would urge everybody to read through Section 6721, and E is actually should be 3 paragraphs. It's too much stuff in there, but I think it's pretty clear, and it kind of really popping out of the page for me, especially today with some of the issues that we've been going through and how much focus we've had on that section today. So that's it. And thank you for all your thoughts around my service dog, Charlie. He really pulled through, like, amazingly, yes. And he's really on a very strong mend, and he's just a miracle dog, as the doctor said. They couldn't believe it. He was totally on death's bed for about 4 days.
Member Johnson, Member Knibber.
I know it's late, but if you reconstitute the Rules Committee that you had mentioned earlier, I would very much like for it to consider requiring the respondents to sign a form when they turn over documents or write something that says there are no documents, that whoever is responding sign, just like in litigation when you subpoena something, because I think that it would in some ways shorten our meetings, because they wouldn't do this dance around it. I mean, they would be more likely to verify, if they had to sign that they were the ones that were responding, it wouldn't seem so up in the air. And I think that might be something rules could talk about. And then secondly, I don't know how to do this. Some departments are show up, like the IT guy is always here. And then some people show up and don't say, Mr. Kinsey is a good example. He comes in and he doesn't complain. But there is beginning to be a significant number of people who show up from the departments that act like it's a problem for them to be here. They act like the people are putting them out. And I think if there was some way for us to use the provision about sending reports or letters to the Board of Supervisors, it's like an act of disdain, like they don't think they have to be here, that it's not important. I'm not really sure, I haven't formulated how to do that, but
just like that?
Sheriff Hennessy was on the radio the other day. You might have seen it. I sent it to H, and he sent it out. And one of the things he commented about was that the sheriff's department is really different from the police department, and you can kind of tell, and it's his style from the top down management. And I just think that they need to somehow emphasize that this is an important part of, I know they might not do it, but I think we should recommend it, that they emphasize to their department heads that this is really important, that it should be an embarrassment for the mayor's Office of Economic and Workforce Development to come in here and say, well, she didn't know. She didn't know how to respond. She didn't know, tonight wasn't a particularly good example, but there have been some nights in here when they just get up here and basically say, you're wasting my time, you're wasting my money,
Well, as a matter of fact, I had a meeting recently with Rick Caldera in the clerk's office, and one of the problems that he mentioned to me is that department representatives will show up at our meetings, and they have absolutely really no idea when during the meeting their hearing will come up. And so, they have families to go home to and whatnot, just as the members here do and as the complainants do. And it might be helpful if on our agendas we could give some indication as to approximately what time they should appear. easier said than done, I guess. We do try to give them some indication with the hearing length indication at the end of each agenda item. It'll say, 20 minutes discussion and possible action and so forth. So, maybe they could divine something from that. But, we have, at any given meeting, we're going to have agenda changes. We're going to have complaints withdrawn. We're going to have items continued. So it's, the predictability aspect there is extremely difficult. But it is something, obviously, that I think we need to consider. Mr. Rustin, if you have any thoughts on that, certainly they'd be welcome now or in the future.
Not at the moment, Mr. Chair.
Okay. In the future, if you have any,
Sure,
they'd certainly be welcome. Member Wolf, Member Chan.
I would just say in regards to that, we probably could look at the minutes, and if you maybe look at the tape, I don't know how easy or how painstaking it is to determine on the average, how long each of our cases take.
Well,
I know.
Cases are different. They vary in complexity.
But it's, is it one an hour, one every 45 minutes? You can kind of space it out and be a little liberal about it, so that people, like Nick Kinsey, can say, well, I'm last on the list. It'll, from the counting the time, it looks like it'd probably be around 9 o'clock.
Well, the problem with that is then if we're really liberal, then all of a sudden we have to wait 20 minutes because we told that person that the next case is going to start at 6 and it's 5:15.
Yeah, no, I understand. I'm just, for the sake. The other thing is when you look at every other board and commission, people sitting around, they're grinding their teeth and wringing their wrists, and same deal too. So it is.
I have one brief item. Mark your calendars for Wednesday, March 16th. That evening, the Society of Professional Journalists NorCal chapter will hold its annual James Madison Awards dinner honoring champions of the First Amendment and sunshine. That will be at the New Delhi restaurant in San Francisco.
I move we adjourn.
Second.
Heard. Adjourn. Thank you all.
Any nominations?